Petition stands allowed by directing the state respondents to pay the remaining amount of land acquisition compensation to the petitioners within a period of 2 months from today. In the considered opinion of this court, taking note of other statutory provisions, more particularly Act of 2013, the petitioners are entitled for interest, and the reasonable rate of interest should be 6% per annum. Accordingly, it is provided that interest be paid to the petitioners with effect from date of first installment paid, transferred to them till the full and final payment is made. If the full and final payment is not made within the period of 2 months from today, the entire balance amount shall carry an interest of 9% per annum from the date of its becoming due till its payment.
Deeply approved.
Some corrections are there. We will get.
May I please, Lordship?
Hmm.
So item number 45, my lord. The matter has become
Published. Yes.
item number 45, my lord. The matter has become infrastructure.
You are Mr. Mubarak. Mubarak. Infractions dismissed on.
May I please, Lordship?
Please.
Item number 17, kindly assume for today. Youngest counsel is not here. Due to illness. Please start the vacation. Once.
You are Mr.
M. Alamgir on behalf of A. Alam.
ALM is here.
A. Alam Anisul Alam.
He is here.
Out of, he is
Okay.
not present.
Admit this appeal. Issue rule. Call for the records. Please this matter for hearing in its own turn. Yes.
May I please, Lordship? Lordship, I beg to mention item number 67
Hmm.
today's list.
Item.
67, last item.
Yes.
Lordship, the respondent number 2 will be filing their reply today, additional affidavit today. So I will be needing some time.
Who is respondent number 2?
And National Health Mission, NHM, Lordship.
NHM is not paid for any exam.
They informed me that they will be filing today, so.
On the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed after 4 weeks. Yes.
Deep
Lordship, I beg to mention item 41. I have taken the consent of the petitioner, Lordship. Lordship, the arguing counsel, Mr. Khera, he is on the bereavement, Lordship. Can it come after the vacation, Lordship?
Item.
41, Lordship. Affidavit have already been filed, Lordship, 2 days back.
On the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed after vacation.
For the respondent, Lordship.
On the prayer of respondents.
Obliged, Lordship.
May I please, your lordship, I beg to mention that item number 20 and 14.
20,
Yes, my lord.
20.
Yes. Adjourn for the day, my lord.
What is there in this case?
Okay, my lord.
Huh?
This council is due to some difficulty, so adjourn this matter.
On the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed on, give a date after puja. 29th, 30th like that, or 30th of October.
43 also, my lord. Item number 43.
43. Yes, there
May
is
it
there.
please, your lordship.
43 PP. 43 case there is there.
Yes, there is here, my lord, but this is not up to date, madam. We require.
Okay,
update.
learned additional public prosecutor prays that he may be granted some time to get an updated case diary. Prayer is allowed. Please this matter.
After vacation.
After vacation, give a date. 30th of October 2020.
25th of
20.
October.
Yes.
May it please, your lordship. I beg to mention item number 22 from today's list, my lord. In this matter, my lord, on the earlier date, while the case was listed before this honorable court, my lord, we were directed to file a rejoinder affidavit, my lord. But we have not filed it, my lord.
Sure.
My lord, our client is in bedridden condition, my lord. We need some time, my lord.
On the prayer of the learned counsel for the petitioner, further 2 weeks' time is granted to file rejoinder affidavit.
Deeply obliged, my lord.
List accordingly.
Your Lordship, item number 25. With instruction received, I would like to not press item number 25 as the case has been settled outside the court.
25 and 26.
Only 25.
Wait for some time. Nothing survives in this writ petition. Interim order was passed. You are enjoying the thing. Already the suspension of 2 years is over. What remains?
Your Lordship, the court case has been settled outside the court.
That we understand. But nothing's your action is against the register of companies. We'll see. Wait. We'll close this. Wait for some time. Can copies.
Can.
When? After vacation.
Possible. If it does not come.
Fixing a date is possible, but getting the scan copies, this is not very enough. Okay, on last date, 4th. Not this one, next month,
Next one.
October. Last date. Huh?
My lord, scan copy.
Scan copies.
But my lord, in this case, petitioner is admitted in the TB hospital, Lordship, can it be before vacation also? It's from Kamrup Metro,
This is verification on 4th,
Port of,
October.
Lordship. Obliged to Lord.
We'll dispose it of. They let them, yes, what do you want to say?
File a affidavit.
Where is that?
Lordship, we have said that, my lord, the mandatory pre-deposit has not been made, and my lord, the stay application has not been preferred before.
Where is your order that that's why you have not hearing the appeal?
My lord, we have.
Any
annexed-
order passed?
Yes, Lordship, we have annexed it along in our affidavit in opposition. Page
Hmm?
252, my lord, running
Huh?
page. In our affidavit in opposition, Lordship, running page 252. Para 2, my lord, page 253, last paragraph.
So according to you have rejected.
My lord.
When have you rejected this? After filing of this writ petition?
Lordship, on my lord, 12/8/2014.
When this writ petition was filed and interim order was passed?
First on Lordship. Lordship, interim order was passed on 9/8/2024.
So you have become wise on 12/8. Isn't it?
Lordship,
We'll examine this matter. We'll take up this matter on next Tuesday. Dr. Saraf, on Tuesday at motions.
In fact, my lord, there is no mandatory provision under the act. They are saying about the circular, now circular.
So that's why we'll have to make some findings on that, whether they can insist on the basis of circular or not. This is the issue.
Lordship.
Okay, if you say that no, I'll deposit, that is a different
No,
issue.
my lord, there is a question of deposit.
Okay, so therefore I'm fixing it on next Tuesday, short time, Thursday,
26.
20,
26.
26.
my lord, the interim order.
Interim order pass LSL प्रतिनिधि.
Deeply aware.
I have some judgments also that surplus cannot override, my lord. The board cannot interfere in the constitutional power of the Supreme Court. That's the Supreme Court decision.
But will it amount to supplanting?
No, my lord, the effect for the same.
We'll see,
But
that's
I will place before lord.
Yes.
Object.
Okay, we file our objection on yesterday, my lord.
He filed yesterday only.
Or it will go to after vacation. It is submitted that in IL, it is submitted that an objection has been filed objecting the present IA on
19.
same is not on record. Registry to verify and list this IA after vacation.
Date may be fixed.
After vacation, that is on. Give it 21st, 25th of October 2024. Interim order, parcel SL continue till then.
Lot obligement.
None appears for the petitioner on call. Notice of motion was issued by this court on 14/10/2020. Full stop. A specific direction was issued to issue notice to the respondent number 4 to 10 by registered post with AD as well as by usual process. Since then, no steps has been taken by the petitioner for last almost 4 years. In view of the aforesaid, the writ petition stands dismissed for non-prosecution.
In this case, we have filed, if I have appeared on behalf of two of the respondents. One is respondent number 1 and also and also for Mr. Shadiha also. I'm appearing. And 3, 1 and 3. The basic allegation is that there was a stay order and during the course of the stay order, the eviction was carried out. So this is 2014 matter. Finally, during the deliberations of last few occasions, I am appearing, Lordship. Because at that point of time, nobody produced the record, and for that we have also seek unconditional apology, Lordship. Now the issue is what should be the compensation, Lordship. That lady is still there, and in our affidavit of the principal secretary, Lordship will kindly come to paragraph 4. Sorry, paragraph 7. The answering deponent gets to state that since the residential house of the petitioner was demolished during the eviction process carried on 18/11/2014, despite order dated 4/6/2014 passed by the Honorable Court in WPC so and so, whereby this Honorable Court, while issuing notice in the said writ petition, was pleased to direct that in the interim, the petitioner should not be evicted. The state government and more particularly the answering deponent is ready and willing to adequately compensate the petitioner for the loss sustained by her due to the demolition of her residential house. In this regard, the answering deponent pays before this Honorable Court that this Honorable Court would be pleased to either reasonably quantify the compensation amount or direct the authority competent to do so to find out valuation of the demolished house of the petitioner, and the state shall pay the directed amount at the earliest possible time. It is pertinent to state here that as on date, the petitioner along with her family are residing in the aforesaid land, and as such petitioner is in peaceful occupation of her land.
Who is for the petitioner? Counsel for the petitioner?
SP Chaudhary.
And what is the other matter that why this other?
In fact, I am engaged by my learned friend Torun Chutia. He's not here also. So,
so see.
No, they only, in WPC. These are all disposed of matters.
Dispose of. Why this matters?
During the interim course of order, Lordship.
There are some civil suit pending and all this. Why I could not
Even I am not aware, Lordship. Only I am appearing for these 2 persons in the contempt case.
Yes. Okay, we'll do, since it's a valuable right is concerned, state has also offered. In absence of the petitioner, will not decide. So we are. Okay. None appears for the petitioner on call, though Mr. D.G. Chaikia, learned Advocate General, is present and referring to the affidavit file submits that the state is ready and willing to compensate the petitioner for demolition of the house during the pendency of an interim, during the currency of an interim order, though it is their stand that they were not made aware of such order.
It was not produced
Not,
also.
not, what is full stop. However, in absence of the petitioner, and in the interest of justice, matter should not be decided. However, the matter, in the considered opinion of this court, the matter should not be decided in absence of the learned counsel for the petitioner. Accordingly, in the interest of justice, matter stands adjourned and be listed on third. We'll see on third.
Lords, highly obliged, Lords.
May it please your lordship kindly pass over the matter for the time being, lordship.
Why? Reason? Reason for passover?
Lordship, files are with my senior lordship. He is stuck in traffic, lordship. I am appearing on behalf of Mr. R. Dubey, lordship.
What is this IA? See, we are having 65 meters on board. If we cross a station, we cannot come back. So we may delay some time in the station, but we cannot come back. What is the matter? This is item number 45,
46.
46. Service in terms of Lajima Court's order dated 23/7/2024, service in respect of the new respondent number 5.1 to 5.5 has been completed. The present IA is filed. For restoration of WPC 5541/2008, which was dismissed for non-prosecution by order dated 19/3/2019 by this court. Where is that order? You have not even annexed the order.
Is it?
Where is the explanation? Give the repetition. While it is explained by the learned counsel for the petitioner that when the matter was listed on 19/3/2019, the learned counsel for the petitioner was on legs in court number 12. And due to some wrong display in the display board, he could not attend the court and reach the court at a later point of time. In the meantime, the writ petition was dismissed. Full stop. None appears for the respondents to object the restoration petition. Considering the explanation and also taking note of the settled proposition of law that a litigant should not be allowed to suffer for the unintentional fault of the petitioner, the order dated so and so is recalled. Full stop. Order so and so is recalled. Registry is directed to restore WPC so and so to its original file. IA stands disposed of. The connected writ petition, which is pending since 2008, be listed on, give a date, before vacation. At least we can fix a date, list it on 25th.
Yes, lordship.
47.
Yes, what is this, Mr. Bhuya?
This is with regard to, my lord, the petitioner's, my lord, right to way was blocked by respondent number A. Now, I have shown from the record that it is a public road, government road. Here, my lord, respondent number 6 and 7 is.
What is this IA?
IA is been filed by the respondent number 8, my lord, with regard to vacating the order, my lord. Dismissal of the writ petition.
Where is the order?
The interim order, my lord, that's been.
Where is the interim order? Give the
Same
repetition.
order to like
Give the interim order dated.
18, my lord. Just- I'm sorry. It's not. 13/9/2019, my lord. I'm sorry.
So it is in your favor.
It's in my favor.
Okay. Heard Mr. Bhuya, learned counsel for the petitioner. None appears for the respondent. Stress respondent. The respondent numbers. Who are these respondents?
Respondents, my lord, 6 and 7, my lord, is GMC, my lord, 1, 2, and 3, my lord. Have
No,
filed their,
who filed this IA?
IA is respondent number 8, my lord.
Huh? No, not private respondent. Sagar Hardware Steel or what?
Respondent, Siddhartha Bhattacharya, my lord. Number 8.
The present application is filed by respondent number
8.
respondent number 8. Praying for dismissal at the writ petition in WPC 4270/2019. Full stop. In the considered opinion of this court, no separate application is required to be filed for dismissal of a writ petition, and a writ petition can either be allowed or dismissed after hearing the parties and considering the pleadings and other necessary materials. First of, in view of the aforesaid, the present IA stands closed.
Deeply obliged.
In the main case, in view of the order passed in IA 366/2019, the writ petition be listed immediately after reopening of ensuing puja vacation. Full stop. Interim order passed earlier shall continue until further orders.
Deeply obliged.
Such application at best can be treated as an pleadings of the respondent number 8. Yes. What is this?
My
Item?
lord, the dispute, my lord, was that I am representing a builder, and the petitioners, my lord, they were supposed to hand over a vacant position of the land to me. However, there was a condition that he used to have a shop in the front of the said building, which was to be shifted into the main premises where he will be allocated shops,
So you are the builder.
my lord.
Now what is his grievance?
His grievance is that the shop cannot be demolished, my lord.
Now why he is before this writ court?
He was before the writ court challenging a notice from the GMC saying that this shop that is constructed now is an
Any interim order? No.
there is an interim order, my lord. But then I believe some understanding has in the meantime taken place between the parties. I am also not in touch with this particular client. It has come up with a
Yes,
long time.
but are demolished already or not?
There is a stay, so demolition has not taken place.
Let them come back for restoration.
I had a word with the petitioner's counsel, my lord. Probably they said
We
they
are
are on
not,
the way.
we are not supposed not to be privy to
Yes, that
your
Yes, I
discussions.
understand.
None appears for the petitioner on call. This matter is pending since 2019. Accordingly, the writ petition stands dismissed for non-prosecution. Interim order, if any, stands vacated. Writ petition WPC for which is the Asmi Commercials, is that it?
my lord.
And what is Ramji Singh?
Ramji Singh is the owner of the land.
Why two writ petitions? Oh, this is IA by Rasmi. Okay. And what is IA of Ramji? Application for 151. Why 151?
My lord, because the interim order in the meantime was not specifically extended, probably they wanted the extension.
Okay. In view of the, you dismiss writ petition 47892. Okay. In view of the order passed in WPC 7892, no separate order need be passed in this. Accordingly, I stands clear. All closed. Yes, what is this?
May I please, your lordship, kindly pass the matter for time.
Why should we? Tell us, where is the order? Yes, Mr. Sharma.
The order is at page 11. The operative portion of the order is at page 12 and 13, where this
Page
honorable.
12 and 13.
Yes. The amount of the contractual bill is rupees 6,07,000, which has again not been disputed by the
Now,
public.
affidavit file,
They filed an affidavit.
what is their stand?
The stand is that, your lordship, they have processed that. In fact, if your lordship may kindly come to the latest affidavit which has been filed by them in the year 2021, they have said that they have sent the matter for processing.
Hmm.
But that is the last of any communication from that regard, your lordship. The letter number 912.
Yes, who are you?
Lordship, I'm for respondent number 2 on behalf of DNAT.
Or on behalf of
DNAT.
Dina, and you?
Lordship, I'm for BTC on behalf of Mr.
Who will
P.
pay the amount?
Lordship, my senior is on legs and.
No, his senior will not pay. Who will pay the amount? Who is the authority?
The authority, your lordship.
Health and family.
It's the PWD, your lordship. It's,
PWD or BTC, PWD is a transferred subject.
it's a transfer subject, yes.
So then who will pay? Have you executed the work under BTC?
No, the work was initially executed, your lordship, under the PWD department. The recitals indicate that. In fact, the affidavit in opposition, which has also been filed by
The
retired.
present contempt petition is filed alleging willful violation of an order dated 8/3/2021 passed in WPC 343/2015. The aforesaid order was passed directing the respondents to do necessary verification as regards the claim of the petitioner for payment of outstanding due
Yes.
and pay the same if within 2 months
4 months.
and pay the admissible amount within 2 months. In the aforesaid order, this court has also quoted the stand of the respondent filed in the writ petition by way of stand of the respondents taken in their affidavits, which goes to show that they have admitted the amount. Full stop. In the contempt petition also, they have filed an affidavit which goes to, which projects that
That they processed. the
under secretary to the government of Assam, that the respondents are taking initiative to pay such amount. However, though the matter is, the claim is pending since the year 2017, no further development has taken place. Full stop. Accordingly, the learned counsel for the alleged contemners are permitted to, are directed to apprise this court on the next date fix regarding the requirement of their time to pay the aforesaid admitted amount to the petitioner. Full stop. List this matter when?
After vacation.
After vacation. See, you have admitted.
Your lordship,
Huh.
on last day, your lordship directed me to file an affidavit. Here the authority informed me that we are not going to pay, health department will pay. Unfortunately, that affidavit.
Okay,
lordship, I
then you write it down. Full stop. Yeah. In the aforesaid view, the respondent may file an affidavit proposing the concrete procedure and the liability and by which date such payment can be made. Full stop. Then you say that this is health, then we'll go to health. Okay.
Is already there. I somehow.
The affidavit may also be filed by the next date fix in terms of this court's order dated 14/6/2020.
There is a service report regarding this one number 4, my lord.
office note reveals that the service upon respondent number 4 is complete. Accordingly, list this matter in the admission column after puja vacation. In the meantime, parties may exchange their pleadings. Respondent number 3.
His Lordship, his name is yeah, in serial numbers 165 and 166 in the chronological list, Lordship. We are going to pay Lordship.
Have you filed affidavit?
No, Lordship, but list.
On last occasion, it says that respondent number 3 has entered appearance by filing wakalatnama and prays that she may be granted 2 weeks time to file affidavit.
Lordship, we are going to pay Lordship.
Huh?
We are going to pay Lordship because new development is Lordship. Chronological list has been prepared as per terms and early Lordship. All the liabilities we are trying to.
We want an affidavit to that effect.
In the meantime, new amount has come.
Okay, so
Some amount has come, my lord. We are going to distribute. Lordship will give just 2 weeks time in the meantime that chronological.
okay, it is submitted by the learned counsel for the respondent number 3 that the BTC authority has received such amount for payment of outstanding dues to contractors, and petitioner's name is at serial number
165, 166.
165 and 165, and therefore they are proposing to pay the petitioners with the, if the fund made available, if the payment can be made within the fund made available, let the respondents file an affidavit to that effect.
Oblate.
In the meantime, there shall not be a bar to pay the amount. You file an affidavit after 2 weeks,
Lordship.
so that we can close it. Otherwise, verbally it will be contempt difficult.
Answer number 53.
Mm.
Today we are going to file additional affidavit, Lordship. Mathematics after a week or after vacation.
On the prayer of the learned counsel for the petitioner submits that they are going to file the affidavit, additional affidavit on the status report.
Lordship.
On the status report. Accordingly, he prays for an adjournment. Prayer stands allowed. List after vacation.
But interim order may be continued.
Interim order pass earlier shall continue till the next date of listing. Then give a date. 30th of October.
Obliged, Lordship.
Please, your Lordship, we will implead new income then.
In terms of office note, which office note? This is item number 54. In terms of office note dated 6/8/2024, service in respect of respondent number 4 is complete. Respondent number 1 and 2 is complete. However, none appears for them. In the interest of justice. Yes.
Well, these are my officers, but I don't think steps had been taken and it has come. Because the.
But office note says service is complete
In the
on 1
meantime-
and 2.
In the meantime, these persons are not in the office, my lord.
Maybe.
Lordship. I'll get the instruction, my lord.
Full stop.
Same is,
Accordingly, however, in the interest of justice, matter stands adjourned. We are just adjourning.
Lordship. Same will be the 55 and 56, my lord.
55 and 56. No, okay, same order.
45 and 50, 45 and 46.
40,
Sir, might be-
55 and
Sorry,
56.
55 and 56.
55 and 56, yes.
55.
Same.
Your Lordship in 58 and 57 also. Same only.
58 and 57.
57 and 58.
All these matters. Okay. List after 4 weeks. You in the meantime, just take
Lordship,
note of it. Otherwise, it's a
One of
contempt we
these I have
cannot
already
say.
filed my color number, my lord. Problem.
Same. Okay. 1 and 2.
Obliged, your Lordship.
Yes.
Yeah, please, your lordship, today I just seek one date because I could not able to trace my file.
Hmm.
So
Now, what is this IA?
Your lordship, that the loan has been taken and
Ah.
it has been settled.
Ah,
Thereafter, in the DRT original application,
Hmm.
they have settled the account, but
Hmm.
later on they have breached the conditions of the settlement.
Hmm.
So against that, they have filed this instant writ petition, your lordship.
Then,
And we
now
have
what is
also-
the present status?
Your lordship, they have not paid any amount to us, or nor it has been settled because here some interim order.
You file an affidavit, you are
It
supposed
has
to file.
already been filed, your lordship.
No, you are supposed to file an objection in IA, is not it?
Yes, in IA, objection is pending.
Okay, Mr. Sharma, learned counsel appearing for the bank, grace for an is granted 2 weeks time to file objection in the IA list according.
Hello.
None appears for the petitioner on call. Service upon respondent number 6 is complete in terms of Lajima Court's order dated 11/9/2024. Accordingly, list this matter after vacation in the admission column. In the meantime, parties may exchange their pleadings.
Lordship, can we pass over the matter for time being? Senior is on legs.
Who is on legs?
Senior, Dinath.
Dinath will always be on legs. He is the senior government advocate. Yes, what is this IA? On where is the order?
That is at page 17, lordship,
Huh?
page 17 of the
What was the direction?
lordship. For the marriage, for this,
Huh?
for the marriage, lordship.
Huh?
Marriage,
You need not read. You tell us.
lordship, paranai.
Tell us what is the
For disposal of representation and compliance with the order in question, the Public Works Department will render necessary cooperation to the district administration. A certified copy of this order will also be furnished along with the representation to the.
This is not the order. Order is at paragraph 7.
There is a land acquisition compensation and that was not paid.
Yes, this is an order of 2022. Simple thing is to be done is the consider is representation and disposal. Any affidavit file? Huh? What is the stand?
Deputy Commissioner Kachal filed the affidavit.
What is
and
his
the
stand?
lordship- His stand, lordship.
Your lordship, I am appearing for respondent number 3. I have filed my affidavit, your lordship. Since we have not received any, we have estimated the amount,
Hmm.
but we have not received the amount from the concerned
Understand,
department.
understand. You have written to them also.
Yes, your lord.
Yes, PWD. After some time.
Yes. Can it be at 2, your lordship?
At 2.
Yes, obliged. 62.
May it please your lordship. Lordship, this matter pertains to levy of service tax
Hmm.
for the year 17-18, lordship. Lordship, before even issuance of show cause notice, Lordship, I have paid the entire tax and interest, Lordship. Payment of tax and interest that I have paid, they have reflected in their order also. Lordship, may kindly come to page 160.
Now, what is this IA?
I was because in pending of this writ petition, they again I had a stay order,
Ah.
but they again issued a recovery notice, Lordship.
Who will represent this? Wait for some time.
SC Kyle, Lordship.
Okay. Wait for something.
May please your password for the time being.
Who died?
Time being.
Who died?
Who died?
Yes,
Who
you do not know. Yes,
Okay,
petitioner number 1. Where is the writ petition? Writ petition.
Pick at 2 o'clock.
Legal has a petition number 1.
The present application is filed for substitution of legal heir of the writ petitioner number 1 in connected writ petition, that is WPC 86875 of 2013. The aforesaid writ petition has been filed for payment of solicium at the rate of 30% and additional compensation at the rate of 12% to the petitioners for acquisition of land of the petitioners. Full stop. The petitioner number 1 had expired on when? Why are you here?
For the time being.
For the time being, expired on 22/7/2023. Full stop. After perusal of the writ petition as well as the pleadings made in this writ petition, this court is of the opinion that right to sue survives upon the legal heirs of the petitioner number 1. Accordingly, the present application stands allowed. Full stop. Registry to do the needful for correction of the cost title. The learned counsel for the petitioner shall furnish amended cost title in terms of the order passed today within a period of 5 days from today. Full stop. A copy of such amended cost title be also furnished to the learned counsels representing the parties. Thereafter, registry should do the needful. Full stop. It will go. Next, write down in the main. In report also heard Mr. Sibura, who has not objected. Write in the writ petition. In view, list this matter after vacation in the admission. IS stands disposal. Yes.
In this matter, ONGC has filed an IA for praying for vacation of the interim order. And if your lordship sees the order of which vacation is being sought, your lordship will find that it was passed after.
So
hearing
it is my case, lordship. So we have filed a petition. So my submission is very clear. We have filed a vacating petition. The issue is surviving till January, lordship. So instead of taking up the vacating petition, lordship, because lordship will have to hear the whole matter, whether it is vacating or the main issue.
Of course.
So my prayer is that lordship may be pleased to fix subject to my learned friend's convenience on 30th for final disposal. 30th September.
30th may be difficulty.
Maybe
Might have difficulty.
I'm also not available. Only
30th maybe we do not know. Maybe I may sit for a 1/2 only. That's why I'm saying. Otherwise, no problem.
well, let us take a chance, or maybe on 3rd, lordship.
third is all right.
3rd.
For final disposal, that observation.
Okay. It is agreed by the learned senior council, both the learned senior councils, that matter requires some hearing, and therefore, instead of taking up this matter, instead of taking the IA, the entire matter can be taken up for final disposal in as much as according to the learned counsel for the learned senior
ONGC.
counsel for the ONGC has expressed some urgency. First of- Considering the above, the prayer sense allowed, list this matter on third
For disposal.
for this for admission hearing.
Highly obliged.
My sincere apology, my lord. I
No
cannot
apology
persuade-
in between.
My lord, yeah,
No
other side
apology in between. You will have to wait till 1:15 or 4:15. Yes.
I am the petitioner in 9 lordship.
What
But,
is the
in
case?
8, I am the respondent lordship.
Bart's overview, what is the issue?
Issue lordship in their petition, the issue is that they were given notice for demolition.
Hmm.
And their plea is that they have not got any notice prior to,
Already demolished?
no,
Okay.
not
So
demolition.
demolition notice was given, they according to them without, this is without notice.
Huh.
Okay, there is a stay.
Notice was given, second one was not given. to them.
Anyway,
That is the
according to them, no notice. So
Yes.
therefore there is a stay.
Yes.
Now what is your case?
Stay lordship, actually, that stay has, is not.
No,
in
anyway,
contract.
there was a stay. What is the
Have
interpretation will come in when we go in depth.
Yes, and our case is that lordship, the construction itself is illegal because the land belong to the mother, late mother of legal heirs. There are 8 legal heirs. The petitioner is one of them and the
So two
respondent.
brothers fighting.
Two brothers.
Two brothers fighting. One brother is saying that my brother has constructed and made an illegal construction, so it should be demolished.
Huh.
Now matter is pending before civil court.
No, lordship, in the meantime, in our application, we have also mentioned that we filed, when we came to know that he had settled the land in mother's and his name,
Mm.
so we filed a revenue appeal.
Mm.
That revenue appeal was allowed by the revenue boards. Against that, they filed a writ petition here against that order. That was also disposed of, lordship. That order last time I had given, submitted before the court.
What was the determination?
The determination was that what we said that the land belongs to then the court ordered in the revenue board itself, it was said that DC will measure the thing and whoever gets, so that will be done. So High Court also allowed that, upheld that revenue board order and directed the
Now what is the
DC
present status?
lordship DC. It is going to be 1 year now in November, but they haven't even issued a notice till now. I have written twice to the.
So what survives here? Everything will depend upon the
Exactly, lordship.
depend upon the determination. He may file a civil suit tomorrow, you may file a civil suit. So at the end of the day, a dispute still pertains actually who owns this plot of land. Isn't it? Now, in that position, can there be a demolition by an authority?
No, lordship, demolition was because he has taken a permission from GMDA. And GMDA stand is that he had violated that. That demolition was because of that, not because of our repetition, no. His case.
Not
lordship-
because of your reason, but because of your application.
No, not only that. The affidavit filed by GMDA, they do not reply to our thing. They are saying that the construction was illegal to some.
Now, what do you expect today?
Lordship, today, at least in my petition, they haven't filed their affidavit till date.
Mm.
Though it is pending from, but GMDA and GMC, they have, GMC doesn't have anything much to.
What is your petition? You want the demolition?
Yes.
You want demolition?
This is, yeah. Because in the revenue board also, before that, we said that it belongs to the mother. And
No,
it
no,
should be-
whatever you said is not the important thing for determination. What is important is what is determined already.
Yes, that is what is determined, that the land will be measured by the DC and then accordingly it will be. So that way the building will be affected, or lordship can take it up
No,
after some time,
Building-
after some
what
days.
building will be affected? Suppose what is the alleged violation again, according to you?
Alleged violation, according to his original lordship, he had only 5 lesa of land in his name, but he got something 3 kota something.
No,
set-
no, what is the violation in constructing the building?
Violation in constructing, the land belongs to all the legal heirs. How can he construct on that?
That is your ground.
Yes.
Can GMDA demolish in that ground?
No, Lordship, actually, though the cases are clubbed together, but the.
No, forget about the cases. What I am asking is, please understand. I am asking, what is the alleged violation for which the GMC or GMDA wants to demolish his house?
GMDA wants to demolish his house because he took a permission and he has built beyond that permission.
Okay, so tell us that it is not relatable to land.
No, land is.
Land is your case.
But
GMC,
GMC, though the cases are clubbed together, but the thing is, their petition is that GMDA had given them notice because they have constructed beyond the permissible, whatever permission was given, they have constructed beyond that, and so the demolition. Our case is slightly, though same.
no, that is what I am asking. GMC cannot demolish a building saying that there is a land dispute. GMC cannot.
No, they have not.
No,
said
no. Therefore, I am asking, what is their ground? If they say that I have given you a permission for this much,
Yes,
you have constructed more,
yes.
that can be their ground.
Huh.
So, according to you, irrespective of your claim or counterclaim, it is having a separate cause of action.
True, that is their case. My case is totally different.
What is your case?
They are clubbed together. My case is that
So,
he has-
therefore, it should be segregated.
it can be, Lordship. I do not have any issue with
Because
that.
if you say that GMC has initiated the proceeding only on the basis of your claim and counterclaim over the land, then GMC's jurisdiction will be excluded until and unless they say that we have given you the NOC and you have violated the condition of the MNOC or bylaw.
That
that-
is in their case, Lordship.
Huh,
Our case is that
So we'll
we
come
had.
to we'll come to your case
Yes,
later on.
let him submit.
Yes, which is your case,
Yes.
Mr.
Wait a second. I do not.
Which case? Mr. Roy, your case is item 8. Dilip Kumar Majumdar. Okay. Yes.
My case is this, Lordship. I have obtained the building permission from the GMD, Lordship.
Hmm.
That NOC, your Lordship, will find at page 19.
Hmm.
This is the NOC, Lordship. Page 19, Lordship, in the name of Dilip Majumdar, Lordship.
Page
Page 19, Lordship.
19.
Annexure 3. And I constructed, Lordship, as per the NOC, Lordship. First of all, they had then, Lordship, the GMD, Lordship.
Now let us see the notice.
Yes, notice, Lordship, page 21. Whereas I, Shri Pritam Saikia, Chief Executive Officer, pass this order as per the powers conferred to the authority under section 88 of the GMT Act for removal of the unauthorized portion of construction constructed in deviation from plan approved by GFC by Dilip Kumar Majumdar, the number so-and-so of Revenue Village, Maligaon. Whereas notice under section 87 was served to Mr. Dilip Kumar Majumdar by number so-and-so.
Okay,
so
okay.
forth, and to also stop construction for RCC structure constructed in violation of the site setback plan approved by GMD NOC number so-and-so dated 2/4/2009. But no reply has been received by the authority till date. Therefore, I do hereby direct Dilip Kumar Majumdar to demolish the unauthorized portion of the constructed in violation of the approved plan as well as the GMD Act and binding bylaws made thereunder and the zoning regulation within 10
Your
days.
whole case is that case of no notice.
Yes,
your case is no notice.
No notice, second so-called notice, and apart from that, Lordship, the demolition power does not vest of the GMDA. After Lordship, it has, demolition power has been given to the GMC only.
Okay, we'll relegate the matter to the competent authority to do the needful.
Okay.
You hear them and whatever you want to do this. Your whole,
We file our affidavit in that Lordship. He got the permission by giving a no objection from a dead mother. Mother died in 96.
that you
And
do not know, that you challenge the NOC. Where is your challenge to the NOC?
Oh, no, we have filed our own writ petition
What is the,
against that because we had given a notice to GMDA and GMC that no, don't give any permission. But in spite of.
okay, we'll come to your case. Heard, Mr. S.P. Roy. Learned counsel for the petitioner. Yes, who is for GMD? Unnecessary these matters are pending. Who is for GMD? Mr. Nayak was here right now.
Mr. Bora is also, S. Bora is also.
He GMC.
GMD.
Then GMC.
GMD.
Huh? Also heard Mr. S. Bora, learned counsel for the petition. By filing the present writ petition, the petitioner has challenged an order dated 12th of May 2011, whereby order dated 12th of May 2011, passed by the Chief Executive Officer, Guwahati Metropolitan Development Authority, Bhangagar, Guwahati, whereby it was held that order dated so passed in exercise of power under Section 88 of the GMDA Act 1985. The said order discloses that according to the respondent authorities, the petitioner has constructed his house over DAG number 489 within bracket old /480, 484, 485 new, patta number 6 old /38 new of the Revenue Village Maligaon, Mauza, Jalukbari, Guwahati, 781 Jalukbari, beyond the NOC for construction, beyond the terms of the NOC issued in favor of the petitioner for construction of such building. The order dated 12/5/2011 also reflects that notices under Section 87 of the GMD Act 1985 was served upon the petitioner to show cause. Thereafter, the petitioner filed a representation before the Chief Executive Officer GMDA on 27th of May 2011, inter alia contending that the purported notice dated 23/3/2011 has not been served upon the petitioner or any of his family member, and therefore he did not have any scope to file any reply to the notice dated 23/3/2011. A further issue was raised in the writ petition that in terms of Section 87 within bracket 1 of the GMD Act, a show cause notice is mandatorily to be served. Then only a demolition can be made. It was also contended in the representation that as per Section 88 within bracket 1 of the Act, no demolition order can be passed without giving a reasonable opportunity to show cause to the affected party. And accordingly, it was prayed that an opportunity of hearing should be granted to the petitioner. Thereafter, when nothing was forthcoming, the petitioner approached this court by filing the present writ petition, and this court, under its order dated 8/6/2011, granted an interim protection to the petitioner. As regards effecting the demolition in question. Full stop. What is the GMD's affidavit? No affidavit. Though the matter is pending since 2011, neither the GMDA authority nor the GMC has filed any affidavit till date. Though the respondent number, who is the respondent? Prasanta Kumar Mojumdar, respondent number?
Respondent number.
TMC is not a party.
GMC is not a party. Okay. GMD has not filed any affidavit. Though an affidavit in opposition has been filed by respondent number 2, who is the brother of the petitioner, and according to the said brother, according to the said respondent, the case projected by the said respondent is that a dispute between the petitioner and the respondent number 2 was pending as regards the actual physical possession of the petitioner and his mother so far relating to the disputed land. However, full stop. Accordingly, and that the respondent number 2 requested the GMDA not to give any permission for construction to the petitioner. However, the GMDA, by ignoring the said application, gave permission to the petitioner for construction of building, which resulted in grabbing of land illegally, which actually belongs to the respondent number 2, being legal here of one.
No, our stand is not only true, Lordship, all the legal heirs.
All the legal heirs, being all the legal heirs of late Jogobala Mojumdar, who is the mother of both the petitioner and respondent number 2. However, such representation was replied by the GMD. Thereafter, an RTA application was filed before the GMD authority by the respondent number 2. And on the basis of such application, the respondent number 2 could gather that already. Where is the reply?
Lordship, it was filed on 29 April 2013.
Did not reply, is not it?
Or GMDA, they gave reply. They said they have not given any permission, Lordship. That was our case. That's why the NOC
And
was not done.
accordingly, the GMDA replied that no such permission was granted to
Yes.
the petitioner. And accordingly, the petitioner preferred, accordingly, respondent number 2 preferred WPC 948/2011 against the alleged construction carried out by the petitioner allegedly without permission. Okay, we are coming. We are just recording the facts. We are not recording your arguments. Let us shorten the things. We'll hear.
Just actual fact, Lordship.
No, actual facts. We are just recording on the basis of her pleading. This is the case of her. We are saying that.
GMD reported the records are not traceable.
That is her case. That is I'm asking. GMD said there is no we are not give you reply. Okay, we'll come to that. Just her case.
Sorry.
However, according to the respondent number 2, in the proceeding of writ petition 948/2011, the GMDA took a stand that in fact permission for construction was given to the petitioner. Full stop.
That's right. Like to point one fact, Lordship.
Just I'm coming. That who went to this against railway notice to the district judge and all?
Mother.
Mother. What is the present status of that?
No, that already given. That's why she was government gave that land. That's why we revenue board. That's why allowed our appeal, Lordship. That was long time back. That was in 80.
The railway was claiming that this is a railway line.
It is sum and substance. It is the case of the respondent number 2 that the petitioner is not the sole owner and possessor of the land where the construction is carried out, and the land belongs to the late mother of the respondent number 2 and the present petitioner
And others.
and others. And they have right over the land for joint possession. In the meantime, the dispute between the parties as regards their claim over the land on the basis of inheritance from their mother went up to Assam Board of Revenue, which by an order dated 16/9/2010,
No, Lordship.
appeal number 155 RAK, what is the appeal number? I think it is 155 RAK 03.
Yes, yes, correct. Correct.
Madam? No,
No,
she will
sir,
have to say.
I'm just checking. I don't want it to be wrong, Lordship. That's
155 RAK 03 dated 16/9/2010.
Please say not the PTPD.
our.
Correct? Okay. Determined whereby the Assam Board of Revenue directed the Deputy Commissioner examine certain things and take a decision which is quoted herein below. Paragraph 7, page 17 of the affidavit 1, 2, Roman 1, 2, Roman 3, okay, page 17 and 18. A further direction was issued to the Deputy Commissioner to complete their exercise as expeditiously as possible and in any case within 16 months. And it was further directed that
6
till-
months.
6 months. It was further directed that till such order is passed, the sub-register or any other authority to ensure that land involved is not transferred by of sale / lease, etc. to the anybody by the partners. In the meantime, where is that order? This court has also passed in direction.
It is there in the record, Lordship.
Which order? Which case?
That was writ petition number 639.
6935?
639.
63995?
Yes, 2010, order dated 9/11/23, Lordship.
In the meantime, writ petition was preferred. Dilip Majumdar is Mr. Petitioner. In the meantime, the petitioner preferred another writ petition being WPC 6395/2010, assailing the order dated 16/9/2010 passed by the Assam Board of Revenue in 155 RA K/2003, whereby 2003 as recorded here in above. By the aforesaid order, declined to interfere with the determination made by the Assam Board of Revenue. Assam Board of Revenue. Reason
Paragraph
if you-
12.
with a further observation that while making the re-examination in terms of the Board of Revenue's order, the Deputy Commissioner shall issue notice to the petitioner as well as the respondent number 2 herein, including other partners of Khiras Patta number 49, and giving them an opportunity of hearing before arriving at the decision. A further liberty was granted to the legaliers of the original Pattadar, that is Jogabala Majumdar, to appear before the learned Deputy Commissioner and to raise their claims on the basis of right of inheritance based on their mother's rights and the mother's right. It is submitted that such order has not been complied till date. Now, these are the facts clear. Now, what is the allegation in JMDA? That he has deviated setback. Okay. Now, to demolish his building, it is to be determined what is the land, because land, he may get less land, his whole building may go.
Yes, correct.
Isn't it? Or if he gets more land, then that setback may still remain. Just that you are for in your favor, when it is determined that you have a share, his whole building may go.
Yes.
And so far relating to the his claim, he may have
No,
that.
still he will have demolition. Why I say Lordship? Because GMDA gave him the permission thinking that about the whole land is his. Because he gave a no objection from a dead mother who died in 96. In 2009,
that's
they have
why-
mentioned in their affidavit.
We cannot go to all this.
No, because in our case, GMD has mentioned that in affidavit. Because we came to know about our writ petition was filed on earlier date than their writ petition. And when we filed the
No,
writ
that you
petition,
have recorded.
yes, at
They,
that
when
time-
they file the affidavit, then also you could know that there is already a permission.
Huh. But when we filed our RTI,
Then it
then
was said that, okay.
they said that it was not there.
That
That's why
already-
we filed the writ
That we
petition.
have already recorded.
Yes.
So what survives in your writ petition?
In my
Yes.
Yes, my writ petition is, it should be there, Lordship. If the land is, it should be pending,
So,
at least last order,
so therefore, this pendency, I'm telling you, this will land nobody anywhere. What deputy commissioner will do? Deputy commissioner may say that these are the names are mutated. At best, who will do the partition?
no, that's why in that order it is mentioned, Lordship. Justice Borua has
Ah.
mentioned that will be given a year to file a petition. That is mentioned, Lordship.
Ah,
That's why
Hmm.
14, paragraph 14, last
Yes,
part, Lordship.
yes.
Lordship, as per Assam Land Revenue Regulation, regulation number 100, there is a dispute of title. Revenue authorities have no power.
That
It
is
must
what I'm
refer the
saying.
parties to the court.
That is
No,
what,
no, that is what is mentioned.
Hmm.
The civil court as per section
Eh,
100 of the regulation.
that is what I'm saying.
Huh.
See, so therefore,
And in
Let us
fact,
not-
Lordship, when this judgment came, actually both of us, we said that we can have a family settlement like type of a
that's
thing.
good. That's
Huh,
good.
Still
sir
we can
also
do.
agreed- sir also
My
agreed
client
to
is
that.
ready.
We are also ready, but the thing is, it is not happening. We openly, I said, in that court
No,
also
no,
I
that
said
is
that.
your subject matter. Let us uh, cut long story short.
Yes.
It's a dispute between all of you, legaliers. He is possessing admittedly, according to you, not admittedly, a major portion of the plot.
Admittedly, they
Yes.
are also admitting that.
No, we are not going to admission. We cannot record it.
Okay.
According to you, he is possessing more than what is he is entitled.
Hmm.
And he has already constructed a building.
Hmm.
Okay. Now there may be revenue authority at best may say that by virtue of inheritance, mutation is granted.
Hmm.
Okay.
Hmm.
Nothing more. Moment there will be a question of partition, actual share, you will have to go to the civil court.
Already a probate case is pending, Lordship. Our one of the contention is that
Therefore,
the division is made by the mother.
Listen.
Yes.
What is pending? We are not on facts.
Okay.
So, in the case of any dispute between the parties and claiming their share, it is ultimately the civil court.
Hmm.
You have an will. Your whole case will be on the basis of will or by way of inheritance. So, everything will depend upon the determination of your share. So, what is the value of keeping all these petitions pending here? We cannot pass any effective order.
No, Lordship, thing is, his petition, I understand they need a notice so that the demolition can be made. GMDA is also saying that, of course, they haven't filed any affidavit in that case. What is their stand? We do not know, Lordship. But the thing is, but our case, Lordship, that we are alleging that the construction itself is wrong. And then when we have this judgment.
But there is no challenge to the NOC.
Lordship, NOC we did not challenge because this was pending, and at that time we did not
But
know.
it came to your knowledge, admittedly, that here was already an NOC. That is not under challenge.
That will, Lordship, we are challenging the whole construction, not only the NOC, his position.
See, madam, that is what there is a fine line. Whole construction cannot be demolished or determined either by the GMC or by this court. Because your whole case is that he has constructed the house illegally. This is our land. Or it's a share land of everybody. On that ground, GMDA cannot demolish. And if permission is not violated, you are not getting the point.
No, Lordship, what is our prayer, Lordship?
Okay, let us go to your prayer. Let us see.
Thing is, Lordship, what I would submit, if they are still agreeable, Lordship, because I want that there should be an end to it. So, Lordship.
And we are ending this.
No, keep it pending, Lordship.
No. 2011, this is scar on us. We are closing it.
Okay.
So let us see your prayer in the writ petition.
Our prayer, Lordship, is at page 9.
Page 9 of
Our
doctor, no?
948.
948. Page
9.
Page 9.
Because, Lordship, since
Yes.
at that time the GMDA had given, GMC as well as GMDA had given us the year that they do not, there is no record of any permission. So, Lordship.
So your case is that if there is unauthorized or illegal, that has already been done by the GMC.
No, what GMDA has done, Lordship, they have said about the unauthorized against the in
As
relation
in
to
terms
the
of NOC,
NOC.
they
But
cannot
what-
do beyond that.
But we are saying that they have to inquire, and if illegal construction, because at that point of time there was
They cannot. Then we will give the power of civil court to GMDA deciding between the fights between the brother and to demolish. That is not permissible.
Lordship, question is when they lied, when GMDA in a RTI lied that they do not have any record of any, and when we came to the court, then they are filing an reply in that affidavit. In that they mentioned that there was a permission given, and they are taking action against the person who gave that false reply to us. In their affidavit, they have submitted that. So Lordship,
GMD has not filed any affidavit.
no, they have filed.
Okay, forget about that. See, madam, whatever we want the issues to be resolved.
Huh.
What is
And
your
that is what even I
what-
want, Lordship.
What is your
What-
prayer?
My prayer is to unauthorized and illegal construction.
No. So the GMD unauthorized illegal construction moment you ask for GMDA to demolish, that is to be determined in terms of the NOC and in terms of the act and bylaws. They cannot decide who is occupying whose land.
No, Lordship, if someone gives a NOC
Hmm.
based on a dead person's no
Now that
objection,
NOC is not under challenge.
we have challenged we have asked them to inquire, and if it is illegal, then to demolition. That is the,
Okay, so your case is that
at least we may be given an opportunity, Lordship, to, because since this writ petition was pending, Lordship.
full stop. Full stop. On the other hand, the prayer made in the connected writ petition, that is in the connected writ petition, that is on in WPC 948/2011, the petitioner in the aforesaid backdrop as recorded herein above has prayed that the GMDA should inquire into the matter of construction of the building by the petitioner and submit a report thereof, and in the event an unauthorized or illegal construction is found, that should be directed to be demolished. In this context, Ms. R.D. Majumdar, Learned Counsel, submits that it is the contention of the petitioner that the NOC was obtained by the petitioner by giving a false declaration in the name of a dead person, that is their mother, who expired on
16/1/96.
16/1/96, whereas the affidavit where the no objection in the name of the mother was given on
No objection, Lordship. Line in there.
yes, Mr. Roy,
Hmm.
according to them, not according to you. This is the difficulty we face.
No, Lordship, because we came for admission.
So what?
Anyway, I do not have
Don't
any,
tell
I
that.
want
In
it
this
to
court,
be.
don't tell
resolved.
that.
Yes,
We
Lordship.
expect the lawyers to be come to the court prepared. Huh?
One,
Lordship,
Oh,
4 May,
No,
4th
when is
May,
this for me? According to
2009.
them, huh?
2000. 4th page 19, Lordship, of my writ petition.
But no, that is not NOC was obtained in the year 2019.
9,
2009.
9.
But she died on
96.
96.
January 1 of 96.
Okay. Be that as it may, to summarize the issues, the case of the GMD is that the petitioner in WPC 2889/2011 has made illegal construction beyond the NOC issued to it, more particularly to the following effect. Full stop. It is the case of the petitioner in WPC 2889 that such notice is in violation of the principles of natural justice and in derogation of the prescribed procedure under section 88 of the 87 and 88 of the GMD Act. The GMDA has not filed any affidavit countering such stand. The fact also remains that the petitioner immediately filed a representation and prayed for an opportunity of hearing. Therefore, in the considered opinion of this court and in the backdrop of non-filing of any affidavit or non-producing any material to conclude that principles of natural justice was followed, this court will have to hold that the order passed in purported exercise of section 88 of the GMDA Act shall not be sustainable under law for non-adherence of principles of natural justice as mandated under subsection 1 of section 88 of the Act. Now coming to the dispute raised by the petitioner in WPC 948/2011 revolves around and as recorded herein above and relatable to their claim over the plot of land wherein the petitioner has constructed the house. An inquiry has been directed by the Board of Revenue to the Deputy Commissioner to ascertain the issue. However, upholding the order of the Board of Revenue, this court in WPC so-and-so specifically observed that if the issues of title relating to the partition amongst the heirs of late Jogabala Mojumdar arises, the Deputy Commissioner may refer the parties to the civil court in terms of section 100 of the Assam Land and Revenue Regulation. Full stop. Land and Revenue Regulation.
9.
So far relating to the prayer of the writ petition, in the considered opinion of this court, the GMDA authority or GMC authority shall be within their jurisdiction to look into whether the NOC granted to the petitioner to construct the building is complied with, that is, whether the petitioner has constructed the building in terms of the NOC issued. And in the considered opinion of this court, the GMD or GMC authority shall not be within its jurisdiction to pass an order of eviction on the basis of the ownership of the land and or claim an entitled title of the pattadars of the said land, and such issues is either to be decided by the revenue authority if it is not relatable to the title, and by the competent civil court when it relates to the title. Therefore, in view of the aforesaid determination, the prayer made in the writ petition in WPC 948/2011 has already been redressed by issuing a notice to the petitioner by the GMD authority. First of all, therefore, in the totality of the matter, and therefore nothing survives to be adjudicated in the said writ petition. First of all, therefore, in the totality of the matter, it is provided that the petitioner in second writ 2889 shall file a representation, a reply to the so-called notice dated so and so, before. No, where show cause notice is a part of record 23.
Show notice, page 24,
Page 24, comma, file a reply to the
Annexure 6.
show cause notice within brackets annexer
6.
6 within a period of, who will decide now in terms of change in law, GMC or GMDA?
Notice from the GMDA. GMDA CEO will decide, man.
Okay, okay, GMDA
GMDA.
within a period of how much? 2 weeks?
My Puja is coming, Lord. Okay.
4 weeks are that submitting the reply. They have to decide.
Within 28th of October 2024. Full stop. Thereafter, the Chief Executive Officer GMDA shall give a hearing to the petitioner and determine the issue. Full stop. It is also provided that as the petitioner number 2, that respondent number 2 / petitioner in WBC so and so also claims to be an interested party, the said respondent may also be heard by the Chief Executive Officer, GMD.
Then, my lord, if it is hard to be heard in person, then the CEO have to issue notice to the board of the
Therefore, you have asked them to appear before the CEO on 21st.
Yes, then.
But in notice is to be given.
So already notice is with you, that annexer 6, that's why I'm asking.
No, because of the order we know. So that is what Lordship is saying, that
That,
since
that is with you. Why should we refresh notice? be
Okay.
issued? That is, you reply to that.
No, so you fix the time.
The 21 at
11 a.m.
at 11 a.m. in the office chamber of the Chief Executive Officer, GMDA, on 21st of October 2024. On the aforesaid date, the Chief Executive Officer GMDA may fix other dates for hearing the parties as per his own convenience.
and Lordship fresh NOC will be here or something.
We do not know. That is the GMDA.
GMDA will decide.
GMDA will decide.
Because if we have to challenge against the NOC, we have to know that something is given or something.
That has already been long back given.
No.
NOC has not been challenged. GMD has not filed affidavit in view of 93 Supreme Court judgment.
That is what we have.
One case.
That is we have.
That's why Lordship. Side well.
All dispose of. This matter should not be kept pending.
And since Lordship has mentioned the other writ petition where here also Lordship will mention that the DC will do the need.
No, you will not mention. That is
But
already there.
Lordship has taken note of this.
I have taken note of this. That's all.
Okay.
That is not, that will exceeding our jurisdiction. That was a different issue appeal. So we'll confine to ourselves only. The peripheries of our jurisdiction.
Okay.
This cannot be decided all these things. Yes. Just give the given note. Yes, next case. Where is your contract with with them?
My lord, I have annexed the work order.
Huh?
Work order I have annexed.
Contract.
Contract I have annexed.
That is the issue. Because in Durga Kishore
Yeah.
and subsequent judgment, and that has been interpreted by RN Construction. Yes, RN Construction. What is that? And RN Construct, in terms of RN Construction, they will consider and do the needful. Because in RN Construction, it was specifically said that if that tender condition concludes, then it will have to pay, isn't it?
Yes, Lordship, it's being an amended petition, Lordship, filed this year only. So let me file my affidavit, Lordship.
In the meantime, let him file the affidavit and I will
Let
proceed
my
to
affidavit come,
contact.
Lordship. In the earlier case, earlier petition, I have already, my affidavit was there.
Okay.
In the amended petition, let me have.
Okay. It is submitted that an amended writ petition has in the meantime filed, and therefore Mr. Nayak, learned counsel representing Public Works Department, Public Works Department press for press for an accommodation to file an affidavit to the appended writ petition. Prayer cells allowed. List this matter after
4 weeks.
vacation. In full stop. The issue pertains to demand of what is called
Forest royalty.
forest royalty and slash deduction of forest royalty from the bills of the contract petitioner slash contractor. And primarily the petitioner relies upon the judgment of division bench in MS Durga Krishna Stores Private Limited versus Union of India and others within bracket Writ April 168/2017. While dealing with similar issue, the aforesaid judgment was dealt in a case in RCN Construction versus so and so. Therefore, the terms of the contract, in terms of the aforesaid judgment, comma, therefore, the contract entered between the petitioner and the employer shall be necessary to determine whether the action of the respondent are arbitrary or not. At this stage, Mr. Bhatti, Learned Counsel, submits that he will keep ready all the agreements in all these street petitions between in the next date fix. List this matter on last part of October.
My lord, let it be fixed in second part of the November.
Huh?
Second part of the November.
November.
Your case is covered by RCN. Nothing.
That I would satisfy your lordship whether I have the case or not.
Yes. November. 14th of November.
Made Bridge.
Yes.
So this is a very unfortunate case. The land of the petitioners acquired way back in 1983-84. But till
Who is
date-
the department?
Irrigation.
Huh?
Irrigation.
Yes, irrigation.
No payment has been made for.
Lordship, may kindly peruse the affidavit filed by my friend, Lordship.
Your
Yes,
friend has said that he is entitled.
Lordship, kindly she pays.
And some only 50% is paid. 50,000 is paid.
No, Lordship. Lordship, may she pays 61, Lordship, of the affidavit, Lordship.
Yes, paid 61.
Lordship. In inviting a reference to the above, I have the honor to state that the requiring department has sanctioned the preliminary LA estimate in 3 LA cases shown below under LS so and so. The fund of rupees 2,16,120.58 at the disposal of the undersigned lordships. The total amount has been at the disposal of the deputy commissioner lordship. As per my understanding, lordship.
No, this is a preliminary.
The other estimate is we have.
It's a preliminary estimate that may increase, that may decrease. This is for the initial. Please deposit us. We will proceed
We
with
have
the.
deposited, lordship.
You have deposited.
That not.
But what is the actual award?
This award they have to lordship.
No, let us see their affidavit. What is their stand? Have you gone through their affidavit?
The copy has not been given to me, lordship. In fact,
They have taken a stand that we are asking the department to pay us the amount and not given. That's all.
they have taken 2 stands, lordship.
Huh?
They have taken 2 stands. In paragraph 5 of the 54, lordship, page number 54.
Page
54, lordship.
Yes, their affidavit.
Lordship.
Yes.
Out of 2,06,626, 56,097 has been paid. And remaining balance is 1,50,529. In 61, they have said different thing, lordship. Page 61, lordship.
What is your stand?
Lordship,
Every day interest is counting. That is, you mark it. If it comes before this court, interest at 9%. What is the statutory interest?
15%.
Huh?
15%.
Are you sure?
Lordship,
Don't make submission
no,
with
under
the
the old act of
old act,
1894.
1894.
Yes.
What is the interest?
Just I'll just section.
That interest will, because on the admitted amount will be.
And they are supposed to file rejoinder also, whether
We
they.
filed a rejoinder also.
In
No,
fact-
forget about, we are not going to
in
dispute
fact,
that
Lordship,
amount.
the last instruction I received is, it is before the L Revenue Authority to.
We are not concerned. How your office runs, we are not at all interested to
This is-
know.
This is correct, Lordship, but we have to
No,
receive the
you,
estimate from the LR.
you do
Revenue
whatever,
Authority.
how the administration is being run, it is not our lookout. But if there is a delay and if the statute provides 15% interest, we will impose that. That much only we are
The only
expressing.
thing is, Lordship, we have to receive the estimate from the Revenue Authority.
We do
Lordship.
not know.
We have not
That
received
is
the
your
estimate.
business. From whom we will get at the end of the day, a private land has been acquired for a public purpose.
Yes.
There is no dispute on that.
Lordship.
An amount is sanctioned, there is no dispute on that. A part is paid, no dispute is on. We are not entertaining any claim of him beyond what he is admitted. That is for the reference court to decide. But moment we say that this is the admitted amount, we may say tomorrow that there is no that is a different issue. Moment we say that this is an admitted amount, there will be an statutory interest on the amount. And in a given case, because we are also taxpayers, in a given case, we may say that these are the parts of delay. So therefore, instead of paying from the taxpayers' money, let it be paid by the officers jointly from their salary. This is, I
my
will
latest-
dismiss his petition. But until and unless you file an affidavit,
I'll file my.
don't argue.
I'll file my. Lordship,
We have expressed our
Okay.
mind. We may
Okay.
dismiss his petition
I
tomorrow.
understand.
That is not an issue.
I understand.
But if we allow,
No.
it will be the statutory interest and that too to be paid by the officer, and we will give an inquiry at whose level, what is the date, and we'll keep it pending.
Lordship.
Some example should go.
Lordship.
When it comes from the taxpayers' money, you can delay whatever. But if it goes from your pocket,
Lordship.
then you will understand. Yes,
After vacation.
on the prayer of the Learned Standing Council for the Irrigation Department, matter stands adjourned and be listed after vacation.
In the meantime, I'll file my affidavit. Lordship. Obliged, Lordship.
Like you mentioned that he will file an affidavit.
Huh? That is what we have said.
Affidavit has not come. Only
No, no, they have said that we adjourned, press for a time to file affidavit.
Lordship. Obliged, Lordship.
We will not compel anybody to file affidavit. It's a prerogative of the, yes. Yes, Gogoi.
My lord, 16 petition is totally misconstrued, my lords. These are forest lands and they are claiming, my lords, right over it, my lords. These are not even, my lord, hereditary, my lord. The right is not hereditary.
May I be allowed to use the second copy, my lord?
Oh.
Because this is a
You are what?
the second copy, because my lord, I
Oh.
could not trace out the file, my lord.
Oh.
How will you do a case with the second copy? We are not have that much of luxury of time.
Then a short date may be
No,
fixed.
no.
Mr. Gogoi,
Right, my lord.
give a copy to her to
Yes, yes.
reconstruct. Huh? It is
Notice
submitted
of
by the learned counsel
I
for
don't
the
know.
petitioner that she has misplaced the misplaced her record from office. Mr. Gogoi shall furnish, she may reconstruct the file. In the meantime, accordingly, matter stands adjourned. The learned counsel for the petitioner may reconstruct the file in the meantime. List of the vacant.
Obliged.
Yes, any instruction?
I need some time. No, my lord, that
Why I am saying is we do not want to waste time. If they say that there is nothing.
In fact, based on the records, the petitioners are claiming their case on a 1989 land policy. The 1989 land policy states stipulation that to be eligible, you have to have at least 15 years of possession of the land. if your lordship peruses the representation, they say in 2015 that they have been there for 15 years, which makes it after the 89 plan came into force. And also the fact that that plan itself says that henceforth, no VGR land can be allotted. So based on these records, I don't think, unless your lordship decides to hear the matter in detail, I can argue the matter, but the records indicate that under the land policy, we might not be covered.
Entitled, yeah.
Entitled.
That I have also seen, but this is a valuable right.
Yes.
They have therefore we pass this order. We wanted to know the present status.
Yes.
What is the present status?
Present status, my lordship, have not been received, my lord, that my lord, that a circle officer, he has been transferred, my lord, so I could not contact, my lord, newly, my lord, they have been joined as recent, my lord, circle officer.
You are giving
I
a
need
chance.
some
See,
time.
these are the very
Yes.
vital
No,
things. I have also gone through it, but
Yes.
then at least we can record that these are the situations.
Yes.
We'll record your submission, but
Yes.
we'll dismiss it for default.
Yes.
If they want, because if we make a determination, their whole roads will end. So without their presence, we will not make any
No,
observation.
absolutely.
Ultimately, these are valuable rights.
Lord, that is true, lord.
Whether they are entitled, not entitled, at least they will have right to agitate, but they are not being represented.
If, my lord, they have to, my lord,
That is why we have engaged you.
they have to apply for, my lord, that new land policy, my lord. They have a right.
No, they have a right, but we want the status from the
Lordship,
circle
lordship,
officer.
lordship.
In that
That's
way,
sometime
we,
actually.
suppose they are still in position, assuming for a moment. We may say that they may go fresh till then or
Lordship.
something, or we may say that nothing survives. That is what we want that.
Lordship.
You have the instruction, it is a
Lordship.
matter of 2016.
Lordship.
More we are trying to clear our backlogs, more we are getting obstruction.
So we are trying our best, lordship, my lord. Sometimes we are wrong. Lordship, fix a date, lordship, then after
Give a
vacation.
date around 11th, 12th, like that. November. Or last part of October. 38th of October. This was item number
18.
same 19. What is this?
My lord, I kindly peruse the last order, my lord.
I have seen that.
Yes. The petitioner is a landless lady, my lord, and a flat affected.
That's why I've requested you.
Yes, my lord. And my lord,
Yes,
I've
fine.
gone to the.
We have filed affidavit.
Yes, my lord.
indicating
SDO
our
has
claim,
filed
my
the
lord.
affidavit, my lord. And in the affidavit, they have said that that a petitioner is a riverside. This is living in a riverside reserve land, my lord. So as per the policy of Assam government, the land cannot be settled in the name of the petitioner. Since, my lord, this is a flood affected person, I found the poem, my lord.
The lady is still there or already been evicted?
There is an interim order operating, my lord. So says there, my lord. So this notification was by this way, this notification scheme was introduced, my lord. That Chief Minister special scheme for rehabilitation of erosion affected families in Assam. And I think, my lord, it will be applied to the petitioner.
Okay,
there's a
what is
procedure-
their stand in the affidavit?
Since, my lord, the petitioner reside in the riverside land.
That is, so they deny that she is not a flood affected?
No, my lord, there are no specimen regarding that, my lord.
So on
Paragraph 5 may kindly be perused. The affidavit filed by the SDO.
SDO is by respondent number? David Kumar Bora.
David Kumar Bora, respondent number 4.
Which paragraph?
Paragraph 5. May I read, my lord? That in regards to the statements made in paragraph 4 of writ petition, the deponent states that it is not a fact that petitioner is depositing land revenue, rather she has been realized penalty TB revenue for encroaching government land. However, no penalty has been collected since the year 2007. As per instruction received from the government, it may be reiterated that land in question is a riverside reserved land.
Okay, so we'll send, we'll ask them to determine till then no
As
eviction.
per this notification,
Ah.
my lord, there is a procedure laid down and the committees are there, my lord.
Okay.
Ultimate decision will be taken by the revenue.
But who will file a representation on behalf of this lady?
She is not representing.
Who is the lawyer appearing earlier?
In the call list, the name of N. Upadhyay, I think 19. N. Upadhyay and HM 1. M.
Heard. Mr. R.M. Dekra, learned counsel, learned amicus. Full stop. This court requested Mr. Dekka to assist this court in the backdrop that the petitioner was not represented by the engaged counsel in as much as counsel, full stop. The petitioner herein claims to be a poor landless woman and victim of flood erosion. According to her, she has been residing over a 5 lesas of annual patta land under DAG number 818 of Aksana Patta number 36 at village Dhokuakhana by constructing a temporary shed. Apprehending her arrest, eviction, she had approached this court. The state respondent has filed an affidavit and has taken and admitted the possession of the petitioner. It is not denied that the petitioner is not a victim of flood erosion, a person affected by flood erosion, not denied that is full stop. At paragraph 11 of the affidavit in opposition, a specific stand has been taken that the penalty within bracket Tozi Bahi revenue was collected from the petitioner for occupying a government land. It is there further than that no penalty has been collected since the year 2007 as per instruction received from the government. It is there further than that the land is questioned is a river side reserve land, and therefore such land cannot be settled. As none represented the petitioner on last 2-3 occasions, none represented the counsel engaged by the petitioner on last 2-3 occasions, and no affidavit has also been, no reply affidavit has also been filed. However, from the pleadings of the parties, it can be gathered that the petitioner is a victim of flood erosion, she is residing over a plot of land which she claims to be an Aksana Patta land, and the state claims it to be a riverside land. The fact is also admitted that till the year 2007, Tojibahi revenue has been collected from the petitioners. In the aforesaid backdrop, Mr. Dekka, relying on a notification dated 17th of March 2015, contends that the governor of Assam has introduced a scheme called, within inverted comma, Chief Minister's Scheme for Rehabilitation of Erosion Affected Families in Assam, inverted comma close, in order to rehabilitate homeless and landless people living on embankments / roadsides, educational institutions, religious organizations, SOR or forest land, golf khas land, VGR and PGRs, etc. The certain procedures and criteria has been prescribed in the aforesaid notification for settlement of such erosion affected parties. Full stop. As from the pleadings of the parties, as well as the affidavit filed by the concerned revenue circle officer, it is clear that the petitioner can be treated as an erosion affected person, and she is possessing a land purportedly meant for purportedly a riverside land, though she claims it to be an annual patta land. This matter should be relegated to be decided by the committee constituted under notification dated 12th of March 2017, that is Chief Minister's Special Scheme for Rehabilitation of Erosion Affected Families in Assam. Full stop. Accordingly, it is directed that the said that the case of the petitioner be considered by the competent authorities in terms of the aforesaid schemes or any other scheme that the petitioner may be entitled for settlement, including the land policy of the state government. Full stop. As the petitioner is not represented by this by her counsel, this court has requested MS Burman to download a copy of this order and forward the same to whom?
To the Deputy Commissioner.
To the Deputy Commissioner, Dhemaji District, is that it? Lakhimpur District. Lakhimpur District, full stop. The Deputy, on receipt of such copy, the Deputy Commissioner Dhemaji shall do the needful as per law and in terms of the observation made in this case. Full stop. Till such determination is made, the petitioner shall not be evicted from the land she has possessing without giving her any settlement.
In this matter, my lord, one thing.
While parting with this record, the court records his appreciation of Mr. Deka, who has ably assisted.
This policy is
court.
of 17, my lord.
Huh?
If this policy is 17, my learned friend informed me that there is another policy of 21, my lord.
Okay, give us the date.
That copy is rightly not available.
Okay, we'll
with me.
say that 25 and there is a subsequent
after.
policy. It is also submitted by the learned standing council where we have stated regarding this 2000 policy. Then you submit that there is also a policy according to the learned standing council for revenue, which is notified in the year 2021. You give a soft copy. We'll upload this order after vacation.
Yes.
Okay. Then we'll see this. First of then this is the order. Then registry to forward. Registry is also to forward a copy of this order to the Deputy Commissioner Lakhimpur for doing the needful.
Obliged.
Close.
My lord, made with your lordship. My lord, this is regarding my lord LPG distribution, my lord LPG location, because I am suffering because of the geographical location, my lord. Because forest. In forest, my lord, they have, my lord, the entire, my lord, location is under the forest area. Entire location. So
Now who has been granted?
My lord?
Anybody has been granted? This till
No, there is a stay order.
stay order.
Stay order. So what happened? I was in raw lot, my lord, I was selected. I am giving a lease deed of a notarized lease deed. But in forest area, there cannot be a registered sale deed, registered lease deed. There cannot be, my lord. So that's why, my lord.
How in a forest area there can be an LPG distributorship?
But they have
No, my lord, forest area, there is a forest village. They are, yes, they are, they are allowed to stay.
Okay, it is a forest village.
Forest village.
Okay.
There is no revenue.
Not
village.
forest area. This is a forest village.
It is a
Moment you
forest-
say forest area, it will be
Yes, yes,
difficult.
sorry. Yes, forest village. my lord.
Forest village is
There is
fine.
no revenue village. It's a forest village. The forest village, my lord, for their.
What is their stand in the affidavit?
They say that you are not given a registered sale deed. That's why you are not being granted.
And do they say that others have given?
No. I have made a categorical statement. Other for also
That's
similar, my lord.
why. That no, according to you, nobody can give a register. This is a special condition. What is this then?
Well, for the first time, he has raised this issue.
No, in the affidavit.
Okay. I'll kindly see, my lord.
This is my pleading. They have not answered.
No, that is he has not raised. I have asked this question.
sir.
There is specific pleading. That's why I'm asking. Any reply has been
But
given.
they have participated, my lord. For the first time, my lord, in the repetition, they have raised, my lord. They have participated, my lord. When we rejected, they have
No, for
raised the issue, my
the
lord.
dismissive petition. How you are proposed? Just for our knowledge, how will you give a LPG? This is not our business. To in that area. That is our question. So you say you want to say that there shall not be any LPG for the forest villagers dwellers.
No,
but
there is a provision, my lord.
what is the provision?
This, my lord, Durgam, Bitarak, or Gramin, my lord. This is under Gramin, my lord.
Then?
But they have not come any, they haven't treated any documents, my lord, that this location comes under forest land, my lord.
Hello, they have
So
located.
let's just let us understand the issue. Don't be aggressive. Both of you are very aggressive. Not necessary to be aggressive always. These are the questions from this court. This may not be our jurisdiction. Can we not ask some questions? So according to you, you know that this is a forest area, forest village.
We never said that this is a forest land, my lord.
So therefore, do you admit that this, do you
No,
say in the affidavit that this is not, according to you, this is
Our
not?
understanding is that, my lord, since, my lord, he has participated, my lord.
No. I'm not asking your stand,
Yes.
Mr. Counsel.
Yes, my lord.
I am putting some question, answer it. What is your stand? I have already gone through
Yes, my
it.
lord. That is not there, my lord.
Do you deny in your affidavit that this is not a forest area? He had made a specific statement saying that this is a forest area, therefore there cannot be any transfer by registered deed, and it is a transfer area. Did you reply that?
But I have not replied to that effect, my lord, but.
You will not reply?
Yes, my lord. Now I kindly see, my lord, the certificate, my lord, granted by the forest department, my lord. But annexure 9, my lord, page 82, my lord.
Question has been raised by the petitioner that the dealership, LPG dealership is to be located in a forest village. And therefore, there cannot be any registered instrument either for lease or for registered sale deed. And therefore, the condition itself is an impossible condition. According to the petitioner, and specifically pleaded in the writ petition, that no parties in that area can grant a registered document in view of the fact that the LPG dealership is proposed to be located in a forest village. To a pointed query, to a pointed query of the court that whether any response has been made, the learned counsel representing
Petitioner,
Huh?
1, 2, and 3, my lord.
learned counsel for the respondent specifically submits that they will, it is not required to be replied to such averments. Okay, now proceed.
Page 84.
Now you argue. Yes, you take your seat.
Your lordship kindly see
Hmm.
that location is, my lord.
Hmm.
That location is, my lord, and mark as a Gramin.
Hmm.
Your lordship kindly see that.
Any statement filed by the state is a party?
No, no.
You make a state party. You implicate the forest and because you have taken a specific stand.
No, my lord, for a moment, kindly
No,
see
we are
page
not
84.
hearing.
But they have registered the lease deed, my lord.
In view of the aforesaid, stand, this court may require to know whether the land is actually a forest land or a normal village as contended by the respondent IOCL. Accordingly, the petitioner is permitted to implead the forest department as well as the concerned revenue circle officer as the party respondent in the case in hand, full stop. The petitioner may file an amended cause title before the registry within a period of 5 days from today,
That will be, my lord, that 10 days, my lord.
10 days, within 10 days from today. And thereafter, and also a copy of the amended cause list to the learned counsel representing the respondents be furnished. And thereafter, list this matter so that necessary instruction can be brought from the revenue authority as well as forest authority as regards the status of the land.
Similar point, my lord, raised before the coordinate bench, my lord. In that coordination, I raised this point, my lord, and that BPCL of not, my lord, IOCL authority, my lord, drop the location. In that case,
It is not, it is heritable, but it's not transferable, my lord. Another act, my lord.
Then why they have get located, my lord, in the area? They can, my lord, easily convert it to the another Gramin
We have
Vikas.
passed the order.
Yes, my lord. The occupancy can give the list.
We have passed the
Yes,
order.
my lord.
Pertains to, my lord, intra-country adoption.
Hmm?
Matter pertains to, my lord, intra-country adoption. And
What is to be done? Tell us.
after the institution of the present writ petition, the government has.
So they
supplied the
have, in
information.
fact, the police says that this is the identity, nothing.
They've given the information.
Then what to be done?
Perhaps in the views of, in view of the information being supplied.
I do not think.
On the basis of paragraph 5, my lord may close it.
See, next issue is the judgments you have raised, points you have raised is subsequent to the earlier procedure.
Not
That
sir.
procedure has been prescribed
To
subsequent.
that effect, my lord, the purpose has been served.
Purpose has been served. So we will not go into all this observation that may hamper in subsequent cases.
Judgment effect is after 95.
That is what I'm saying.
After 95.
But procedure prescribed should be related. At that point of time, they could not
is-
anticipate
no,
that this is required.
Nothing is-
Because till the 80, in the 80s, the law was fairly unregulated. Only after.
See, we are having sympathy,
And I
but not
understand.
beyond.
But then ultimately purpose has been served, so.
Learned
nothing.
counsel for
We
the
also tried
petitioner
this.
submits that in view of the affidavit filed by respondent number 3, the petitioner has obtained the instruction for obtained the information.
Written instruction, I don't have to withdraw.
In view of that affidavit, the present the learned counsel for the petitioner wishes to withdraw the present.
That written instruction to withdraw, I don't have. Your lordship can simply close it on the
Okay.
basis of
Okay,
the.
it's okay. Then
Quote the paragraph 5 and.
Your lordship may quote the paragraph 5.
no, we are not quoting.
Not lordship.
This is affecting rights of others.
Lordship, then lordship may simply close
See,
it.
you do not know how that mother, what circumstances, where is she,
Then
is
lordship
there.
may simply
That
close
we
it
can.
after.
Will, that in view of the affidavit, the learned counsel for the petitioner submits that in view of the affidavit filed by respondent number
3, lordship.
respondent number 3, disclosing the required information,
Lordship.
comma, the writ petition may be closed.
Lordship.
Accordingly, the writ petition stands closed.
Lordship.
We cannot,
Lordship.
My instruction of the record.
we will have to have of the record, she has,
She has
okay, then
been
fine.
able to identify and they've established contact. My lord.
That's good.
Then nothing. Then
That
lordship
nothing,
may-
because otherwise we cannot, we'll have to
there.
think the right of both. And more particularly in Indian context, it's not, we are not in.
And lordship in such kind of cases.
Recently, there has been a development. The adoption regulations 2019 have come into picture. And now the law has been very, my lord, the structure has been made.
That part
But in
other.
India context, subject to what the parliament makes law, it is a different. But Indian context, in certain cases, there will be no adoption in these cases.
Lordship,
No, people will not go for sending this child, unwanted child to the
Lordship.
houses and all.
Because recently, this 2019 regulation, my lord, the framework has been made. And in this case, my lord, since there has been, they've already established context.
Yes, Kogoi.
This is a case actually covered by division bench. I shall first, my lord, say one truck, my lord, load of limestone was seized by the forest officials. My lord, they have not given the seizure also. They have informed the police. Ultimately, they have given the seizure. Please at page 40.
We are ready to release the vehicle. Qua vehicle, the part of the petition, qua vehicle is gone. I have taken instruction. We are ready to release the vehicle.
My lord, the only vehicle, my lord, your lordship see, my lord, that the article, my lord, has been sent for analysis.
Hmm.
And it was found that it's not a stone, it's a limestone. Then the director of minor minerals has written a letter, page 63.
Hmm.
My lord, it said that forest department has no authority. It is my lord, mines and minerals department, it is authority. And division bench judgment, my lord, PIL, your lordship may see. That has already been, my lord, clear.
You want to release both?
The limestone issue will be open, my lord, because, my lord, what had happened? What had happened, my lord? This was a crusher, my lord. It was established by the consent by the, it was regulated by the forest department. He was permitted to, indulge in business of minor minerals and also forest produce. What had happened, my lord, as minor minerals, my lord, we don't cover it. Limestone, that is an admitted fact. But taking cue from that, taking advantage of that, he uses the crusher which is regulated by forest department to crush limestone. He even goes to the extent of printing his own challans. And that is the issue, my lord. And I have also few judgments, my lord. My lord.
Okay,
I can.
so far relating to limestone, we'll decide after
Yes, yes,
vacation.
Vehicle I can release, man.
No, that will need some deliberation. I have also gone through.
Yes, man.
Because
I also
the-
have a judgment, my lord.
No, the judgment will come later on.
Yes,
Judgment is not
Supreme
soon.
Court said, my lord. And our one, this one.
We'll take help of the Supreme Court when we are confused.
My lord.
And we could not be guided ourselves that what should be the law.
Oh.
Then we'll take Supreme Court's help.
In that case, man, our own court, my lord. This honorable court, my lord.
Are you hearing?
Oh,
Are
no,
you going
no,
for-
no, no, no. This is.
Then why have to be
No,
keeping
I'm
as a
relieved
judge?
that I'm relieved today, my lord. No,
For
we'll
last
release the
5 years,
vehicle.
my lord, it is like that.
No, we can do it, but see,
today,
in the second half, Advocate
yes.
General argue a matter, which will take maybe whole, the second half, we want to finish it off.
My lord.
And if time permits, we can finish
No,
the
no,
other
yes.
matters, then we'll proceed.
That will be
If
too
you
far,
say-
my lord.
Any day, my lord,
It's a
your
flight.
lordship, my lord, may to release the vehicle.
Okay.
And for this matter, my lord, another date may fix. my lord.
We'll fix it.
Since 19, my lord, it is there.
The present repetition is filed assailing seizure of a truck of the petitioner carrying limestone. The
On
one of the
13/3/19.
Huh?
On 13/3/19.
on 13/3/19.
Well, whether vehicle is existing or not, I don't know.
Why no interim order was there? 19. And one of the contention of the petitioner is that minor mineral, limestone being a mineral produce, the forest department shall not have any authority to seize such minerals.
Right.
Per contra, Mr. Gogoi, Learned Standing Council for the Forest contends that though per se limestone may not be a forest product, may not be, may be a minor minerals, may be a mineral, but it also a forest products. And therefore, they will have jurisdiction. Full stop. However, Mr. Gogoi submits that he has instruction to submit that the forest department is ready to release the truck seized by the truck which was seized. Full stop. However, the forest department would like to advance their argument on the contention that they have their jurisdiction to seize limestone being a forest produce. This matter needs further consideration. Accordingly, list this matter on 21st, 21st of October. Huh?
My lord, not 21st, my lord. It may be on any other day, my lord.
Give a date as per both of you.
24th.
24th of October 2024. In the meantime, the vehicle bearing registration number
AS 24, I think, right?
Yes.
Registration number?
AS 24C
Hmm.
2466.
2466 be released to the petition. In fact, Swas,
Yes, Your Lordship, what has happened? After this honorable court order, in fact, there was a policy for condoning this delay and there was a provision for penalty also. What instruction I have received that we have paid all the penalty. We didn't avail the policy. I think if Your Lordship may keep it for another date, because he wants to confirm, director wants to confirm with the CA whether we have paid the penalty. Then all regularized.
okay, we are fixing next week.
Next week.
Just have the instruction.
Then I will withdraw the
The learned counsel for the petitioner submits that he may be granted 5 days time to obtain instruction whether there is any any cause of action survives in the present writ petition and IA. Prayer is allowed. List this matter on Monday.
Next.
23rd, not 23rd. 23rd is a Monday, not Monday.
Not
Then
this-
maybe on Thursday. 26th.
Yes. Interim order to.
Interim order partial and continues
Obliged.
till then.
728.
One instruction I have received, but it is not adequate, my lord. One small para they have furnished, my lord. Let it be after vacation, my lord.
On the prayer of Mr. Gogoi, learned counsel, standing
Minus
counsel for
taxation.
taxation and taxation department, matter stands adjourned and be listed after vacation. Interim order partially shall continue till then.
My pleasure, lordship.
You are
This, my language,
your Patta land. This is they want to make it a bird sanctuary.
Yes.
And who is this petitioner?
I'm petitioner.
No, there is two petitioners.
Here, my lord, earlier.
Sadzan Min Palam.
Yes, that was initial case was there. That time, this you wanted to make this one, fish, fishery. Thereafter some litigation was there 2003 or not. One PIL was there, that is when we said. Then PIL, it was said, if you made any bird sanctuary, then Forest Department is directed to acquire the land as per procedure of law, then only it shall be. That is the PIL discussion.
Now, what is the status of this land?
Now, what happened during pendency, because as these orders are not complied, I filed that cases 492, 2 cases, 20. Then without giving any affidavit
So
or
this Sadzan Min Palam
that-
o Moidan Khetra.
much.
Moidan?
That was hearing, then we were insisting for filing this one, you complied that order of the
Division bench.
division bench passed the PIL as well as order passed by the single bench. Then during pendency of this, they have tried to acquire our land, not acquire, requisition they wanted to. We have challenged this one because if you want the land, you can take it.
It's a
Because it's
Patta land.
Yes, we have Patta land, we have already mentioned there, it is there.
What is
And
the affidavit?
affidavit has not at all come from this forest department.
And
Last
what
also
about the
it was
revenue?
given. Last
Revenue,
also
what
opportunity
revenue
was
said?
given.
What is the stand of the revenue?
Revenue is telling this one will acquire the land if it is this one. As per
No,
acquisition.
no, AQR will come later on. You say that this is your Patta land.
Yes.
What the revenue says?
Revenue say they are not denying on that point.
What is the affidavit revenue?
Affidavit, your lordship will get it.
Forest has filed affidavit.
My lord, we step in. First, government has to notify. There is a procedure. They have to acquire and hand over us. Proclamation has to be issued. We step in only that time, my lords.
Now, initially it was a
Otherwise,
requisition.
My lords,
It was only initially requisition.
my lords. And it's what I can get from the affidavit of revenue, my lords. But the state has to take a call to declare this, my lord. There are some rules, my lord, for wetland
No,
protection.
no, from where it has come? It is from PIL.
Yes, my lords. It's a PI.
Why this necessity of declaring this bird sanctuary comes? From PIL?
Yes, my lord. There's a
Where is
PI,
that
my lord.
PIL's order?
PIL is at, my lord, page 38. It
38
starts
of which
38 of petition of 4925 of 2020.
4925.
4925.
4925. 4925 page.
It starts at 38. Annex 11.
What is the direction?
Lordship will get it. Here, 9. 43, na?
9 and 10, 44 and 45.
No, this is writ petition.
This is
Yeah,
PIL, madam.
this PIL order is,
WPC.
PIL order was there.
Page 36.
No, left, state to your lordship.
Which page is yours?
No,
Page
38, madam,
37,
No, no, sir. 38 starts, it's a PIL, madam.
PIL Miller. PIL order is
At 44, Lordship will find the conclusion. It's
Okay, we'll come back at 2.
Yes, yes.
Yes.
Apologies, but I'd like to mention item 48, my lord. Then the other side is there, my lord. Lord,
What
dismiss-
happened in 48?
Lord, dismiss. the
Oh,
order
which
for
one was it?
non-discussion.
Huh? That I have already signed.
Lord.
What was the matter?
My lord, there was an order of demolition issued by the GMC authorities, my
Ah.
lord. A private respondent had complained.
Ah.
My lord, we came to this honorable court had passed an order of stay. My lord, in the meantime, they filed an application for vacating of this stay orders. My lord, a talk of compromise is going on between the parties. Even on today, my lord, there is an instruction that there is certain compromise going on. My lord, may kindly allow that matter may come up after vacation, my lord, we will.
Any talk of compromise?
My lord,
You do not know. 47.
48, my lord.
48.
My lord, interim order. my lord. Highly obliged.
কি হলো ঘোড়াটা কি করবো বিকল্প করে দিলে আচ্ছা বিকল্প দিলে তো ওটা নামাতে কি করবো বেলেগের অ্যাপ্লিকেশন দিয়ে দিব আপনার ভেকেশন আপনার ভেকেশন দিয়ে দেবো
ठीक है ना ठीक है
হ্যালো ইমিডিয়েটলি হবে
Last one, no?
That was after that visit. ইয়াতে থবচোন বাহিৰৰ বেগটো এইবিলাক দেখাম কাপোৰ দেখা নাছিলো কেইটা বেগ আছে বাহিৰত
লগাইছিলে ফালি দিলে ফালি দিলে পৰীক্ষা লগাইছিলে ফালি দিলে
এইটো নহল নি?
For disposal or any affidavit is required.
What happened here?
Another issue, my lord, technical, but this society which is before lordship is not registered.
But their petition was earlier entertained. Then we cannot say.
Too late.
Too late in the day.
Hear me, Lord, one thing, before submission,
Where is that give us the PL order? Let us just see, understand.
I am producing for 42925 for convenient your lordship for.
Okay. 4295, yes, 4295 page.
Page 38 it starts, cause title, 38 Annex 11. It's a PIL 6 of 2017.
Final direction.
Final direction lordship will find
Page
40, 43, 44, 45.
para 9, my lord.
Now, where is the decision to implement?
There is no decision. Till
Then-
now, my lords.
Then where is the question of land acquisition?
My lord.
Because what happened?
See, court has not directed you to do it. If you take a decision, you can proceed. Where is the decision? If no decision, there is nothing to be, nothing survives in this writ petition. Second part is, as and when decision is taken, they will have to comply with this order,
Yes,
that's
my
all.
Yeah, that's all.
And that is why.
Why should you argue?
Yes, that is why second petition I have come before Lordship.
Where is
Only-
your notice to acquisition?
No, that is the next case, my lord. T13. That is
Notice of requisition was given.
requisition, that is.
Now, where is the decision?
Notice. That is why no decision is taken, but they have given me for requisition of land immediately. That too, they would have required me.
No, that we understand. Requisition only on always in immediate nature.
Immediateness.
That fine, they may regularize the requisition, that is a
Yes, yes.
different issue.
That is my cast of the case.
That is
There
okay,
is a
but where is
big
the
part of the case.
decision? Or we can say that the attempt to requisition the land itself shows the decision.
In a manner it is, but
Nobody is aware of anything, yes.
In all ABD results, item 29. Our ABD business, the last page, committee was constituted.
No, please tell us. In the PIL, you say, if you want to have a bird sanctuary there, you can proceed and take a decision.
Right.
First of all, where is the decision?
After this constitutional committee for that decision, my lord,
uh,
taking that decision,
uh.
that after this, what had happened, it was nothing.
That's why
This was
I have made a comment, nobody knows anything.
This was in 22.
The fundamental thing is that there was a decision was to be taken that is to be followed by acquisition.
Right.
Now, if no decision, where is the question of requisition or acquisition? Then we'll set aside everything and we'll give you permit to do whatever you want to like in terms of this order. We are doing wastage of time, nothing more.
That is my charge.
Criminal wastage of judicial time.
This is
On the prayer of the learned State Council, matters stands adjourned and be listed on.
after vacation.
Give a date.
Any day.
First week of November, give a date. 7th of November. In the meantime, the state shall clarify whether any decision has been taken for converting the land/water body in question for a bird sanctuary in terms of the order dated. Quick.
16 to 2010.
Order dated 16 to
2010.
2010.
Passed in
Passed in PIL number
6 of 2007.
6 of 2007. And whether the state is proposing to, if such decision has been taken, whether the process for acquisition/requisition has properly been initiated in this regard.
Right.
That is the issue.
That is the issue.
Yes, then.
But
Why we fixed it here?
I'm sorry, Milord, I could not appear in the first episode. Milord, I appear for the respondent number 2, Milord. Milord, the instruction I have received from the respondent number 2 is that, Milord, in fact, he has left that particular office on 20th of July 2017. Order was passed thereafter and the contempt case was filed in 2023, Milord, wrongly implementing him as a party, Milord.
Okay, forget about that. You are a senior government advocate. It's between you and us. Forget about him.
Lordship.
Now, what is the stand taken by the Deputy Commissioner?
Deputy Commissioner stand, Milord, in fact, for DC, my Lord,
Yes, what is your stand?
Your Lordship, we have estimated the amount and we're asking for the amount.
You want the money? There is no dispute that land has been acquired. You want the money. And who will pay?
The requiring department.
Who is the requiring department?
This is for border fencing, Milord, for the.
Who will represent them? The department. You are a senior government advocate, you can represent. So forget about whom you are representing. As a senior government advocate, you obtain instruction.
Lordship.
And in the meantime, if necessary, he will file application. What we are not concerned with that.
Honorable.
A stand has been taken by the respondent collector / respondent number three collector that they have sought for required fund amounting to rupees 11,41,666 in connection with payment of Jirat in respect of acquisition of land for construction of India-Bangladesh border road and fence at village Harinagar, Part 1, PH, silo page 21, Hartikar, pertaining to land acquisition case number 18/2007-2008, but such amount has not been deposited by the requiring department. Thus, inasmuch as the grievance of the petitioner is that in spite of direction of this court, no payment has been made against such Jirat and land acquisition compensation. In the aforesaid backdrop, this court has requested Mr. D. Nath, learned senior government advocate, to obtain instruction as regards status of deposit of aforesaid money as claimed by the collector as well as collector from the concerned department. List this matter on
Lordship, can you keep it after the reopening? Lord?
reopening. Yes, of course.
Lordship.
First week of November.
Lordship.
5th of November.
Lordship.
Possible? 5th of November.
Right.
He orders naki? Yes, Gogoi, who will appear? Union of India.
SCKL Lord.
Yes.
Lordship. He is on Lakes, Lordship.
He was on election for whole day. Then you would have to arrange something. Or we are staying this.
Lordship, stay has already been
Granted. Okay, then enjoy your stay.
But Lordship, this matter can be disposed of, so every time they are
But
taking
but
time.
he is not here. You enjoy your stay. It is submitted that Mr. S.C. Kyle, learned standing counsel for GST, CGST is on legs and therefore an adjournment. Prayer for adjournment is made. Full stop. Prayer is allowed. List this matter after vacation on a date to be fixed by registry.
Lordship, can it be coming for hearing, Lordship, instead of orders? Because this.
No, we'll decide that in order date in the hearing column. Interim order pass earlier shall continue. Already admitted?
Not
Admitted.
not
So we'll come not hearing now. Yes. Yes, Gogoi.
My lord, here so far as one relief is concerned regarding restoration of the registration, that has been done.
Done.
Now, so the impugn order is concerned, it is the central government, my lord, Mr. KL will have to, my lord, take a call. Look, sir.
Yes, it
These
is,
are lakes, my lord, in
it
that
is
case, after
submitted by Mr. Gogoi, learned counsel for standing counsel for taxation department, that one of the prayer made by the petitioner, that is restoration of registration of GST, has already been done. However, as regards imposition of penalty,
yes,
same is to be addressed by the CGST, by the central government. Full stop. Learned counsel representing Mr. S.C. Kyle, standing counsel for CGST, press for an adjournment. Prayer stands allowed. List in the month of November 2024. Any interim order?
Yes, sir.
Interim order pass earlier shall continue.
Bless you, Lord.
Yes, no affidavit.
Today I file affidavit, Lordship.
You have filed.
Lordship.
It is submitted that the Union of India has already filed an affidavit today. Same is not on record. Registry to verify. GST authorities have filed an affidavit, okay? Same after in the month of November. Any interim order? Interim. Anything survive?
Yes, survive, my lord. Yes, stay order, my lord. I am the highest bidder. I was not being granted regarding Sam and Gahel Mahal, my lord.
No fishing season, you can wait after till vacation.
My lord, so actually separate litigation matter has been listed. But today also listed with intention to dispose of the matter. But they did not furnish any documents, my lord. That is why their tender has been rejected. They had not furnished the turnover, annual turnover, income tax certificate, then my lord, GST, nothing ever. Moreover, license has not been there for this, my lord. So that is their tender has been rejected. Although there has been there, but
you are not highest valid bidder.
My lord,
Not a valid bidder.
valid. He is not a valid highest bidder, my lord. I am the valid highest bidder. That is why.
But
What was the
Who is enjoying now?
No one. No
What
one.
is the department? You are AFDC. No, huh? Okay, BTC. Who is fishing? Or you are huh?
Gabriel Mahal.
No, mining clearance yet to be get, my lord. Nobody getting mining clearance, my lord.
Because of the stay order, we are not. The authority could not send me the final.
What do you propose today?
Cleaning completed in all cases.
We are also not in a hurry because we need to get the environment certificate. But I am aware that I am not hurry, my lord.
You are in a hurry. Money deposited.
Everything has been completed, my lord. I am open the
How they can without
mining
environment clearance
certificate we
even
obtained, my
issue
lord.
a tender?
Yes.
Okay, 21st. As agreed to by the learned council for the parties, list this matter on 21st of October 2024.
Interim order pass out.
Huh?
Interim
order, huh? Reopening. October. No scope now.
No, my lord.
Today is the last day for long hearing.
No, my lord.
It is made clear.
21, my lord.
For disposal. Of course, motion and all is
Yes.
most welcome, but for disposal,
For disposal, it is-
until and unless very urgent that some stay is there, there must be some, Mr. Chaudhary, there must be a vibe of the vacation, isn't it? Until and unless lawyer seeks adjournment, where is the vibe? Yes.
Not evident.
Interim order continue, my lord.
No vibe nowadays.
Earlier we used to have.
No vacation vibe, no motion, nothing. Yes.
Interim order pass earlier shall continue.
Interim order pass shall continue.
Deputy.
Huh? First week of November. Give a date. 25th, no, November, first week of November. 8th of November.
Very clear, more consumer. Next.
Yes, what is the updated status?
The in principle decision has been taken.
That in principle decisions long back taken.
I'm a lordship, I'm in a fix, I'm myself in a fix. Lordship can do one thing, lordship, the minus has to be signed by the chairman. Chairman has not come to the office. So one can.
What happened to him? COVID? No, COVID is also there.
I don't know, lordship.
Based on that, they should proceed.
I can do one thing, lordship, I can bring all the records also.
No, do not want any record. His prayer is in fact been redressed by the authorities. A decision has been taken.
Acted upon.
Acted upon.
Lordship, the problem is that there is a monetary transaction. All problem are there in the FDC, lordship. So I also do not want to take the responsibility.
Everybody.
No, my lord, that I appreciate, but for that last 6 months, it is going like that.
That I have seen. I
No,
think
I
one
have-
of the cases having longest orders.
Lordship, but we have accepted the prayer, lordship. In lordship, can it be after 5-7 days? I will do it something, lordship, by giving it.
It is reflected in the order dated. Which is the first order?
Lord, in fact, order to customer.
Hmm.
In fact, 11/9/24 also, my lord.
11/9/24 na?
Yes, yes. Approval has been given by the court.
ठीक हो ना?
Previous orders also.
It is reflected from the order sheet that way back in the month of June 2024, some assessments were made and it was intimated to the court that a decision may be taken by the respondent authorities for granting benefit to the petitioner out of such reassessment. Subsequent orders passed by this court reflects that in principle decision has already been taken.
In fact, if your lordship would kindly have a look at order dated 22/3/24. On that date itself, it was placed. 22/3/24.
22/3, na?
After that, only a few months ago, lordship, board has taken.
22/3.
Board was constituted. No board.
Was already been done. Huh? Already been done, and report was also placed, and it was also submitted that the matter will be placed before the board of director meeting for approval, so that benefit can be granted to the petitioner. The matter is still lying at that stage.
Matter is this.
Though Mr. Sharma submits that already board has approved, only requirement is that the issuance of the resultant order, which is to be signed by the chairman of the board.
No, not the order, the minutes of the board meeting.
Anyway, in the minutes of the, ultimately that minutes he'll have to file an order, minutes of the board meeting, not order, by the chairman. And he submits that as chairman, he submits that the same would be done at the earliest, and therefore he seeks for an adjournment. Prayer is allowed. List this matter on.
I have to vacation.
38 or third?
Third, Lord. Third will be better for him.
Third, second is a holiday. Third.
Deep clear.
38.
Same vibes.
You are having the advantage of the vibes. Where is the other side?
Private hospital also is not there.
No, Masari is coming. Masari is coming, my lord.
Okay, wait for some time. Yes, Mr. Seju. Yes, what is this?
The pleadings are complete, madam. Pleadings are complete, lordship. Today we have received an affidavit of opposition filed by the respondent number 5, the private respondent, lordship.
It is submitted with the learned counsel for the petitioner that an affidavit in opposition has been filed by the respondent number 5. Full stop. And therefore, the learned counsel for the petitioner shall require some time to go through the same and response if so advised. Accordingly, prayer for adjournment is made. Prayer stands allowed. List this matter after vacation.
That may be feasible, lordship. As for the convenience of the court, lordship.
Our convenience will be 25th.
25th of October. Yeah.
No, 2025. When?
Lordship, any day, lordship.
Give a date, Musumi. 6th of November.
Lordship,
Yes.
I'm for the item 65, my lord.
Ah.
Motion. My lord, I took a water supply connection from respondent number
No,
12.
there is already an interim order to.
No, that is not to me, my lord. Already disconnected were restored. My connection was later on disconnected.
Who is the state?
THC.
THC. What is this? I am not getting anything. Water
this-
supply has been delegated to the society.
My lord, the repetition would at all lie, my lord.
Why?
My lord, it's basically the dispute between the two committee with a similar name.
It is a public service
Yes.
delegated by, which is the responsibility of the state, delegated to a private player. Can you say that a citizen can be relegated to a civil court in that circumstances?
No, but so far as the disconnection, if at all, my lord, given that has to be, my lord, because interim order is already there. I think she is the.
Who is supplying the water to her? Tell us.
THC.
Huh?
I am in the item 14.
Your already interim order is given.
Yes, lordship. Already, lordship.
Yes, where is the
Lordship.
PHC?
So far as, my lord.
Mr. Gogoi,
Second.
who is PHC?
Ritik Gogoi.
Call.
Whether, my lord, in the second repetition, the instruction is that there is no connection at all to her, my lord.
We'll ask to verify the PHE department.
The whole thing, that's what, my lord, the PHE is, my lord, is on the season of the matter, my lord. It should inquire entire things and, my lord, submit a report.
PHE, and take over the project. We are exercising our jurisdiction.
Can we get some time?
No, this is not done. A water supply, which is your responsibility, is being given to a private party, society, and for their fight, which citizens will, who is in fault, we are not concerned. Citizen will not get. Even in case of red dispute, we can pass an order for restoration of electricity and water.
Lordship.
Forget about this. What is this business?
Lordship, actually, after completion of the project, as per the memorandum, it is handed over to the locality.
So you don't have any responsibility. This is constructed on whose money?
PHE does.
So it is taxpayers' money. Can you say that we have constructed and hand over to somebody else and whatever like they will do?
Also, the bylaw says, Lordship, it is the superintendent of engineer. If any dispute arise to resolve this issue. And they are also overall also controlling the bank.
I have
account also.
instruction tomorrow.
May I submit one thing? Well, let the PHE make an inquiry, my lord, exactly what is.
No, enquiry, everything will pass, but by the week, by tomorrow is a Saturday. Monday, by Tuesday, we want the power restoration of the water supply.
I'm a 65 years old retired lady living singly, my lord. It's very difficult.
When was your disconnection?
I got the connection on 11th of August and it was
And when it was disconnected?
13th, my lord.
13th of?
Monday, August. Only after one day.
A 65-year-old lady is without water from 13 August. I hope that she can wait till, and she has filed a writ petition in the month of September. And she cannot wait for 2 days.
Definitely.
Then we are
she
issuing
can-
a notice
Oh, my lord, definitely I can wait.
and
for
we'll
2 days.
examine whenever is required. Then be reasonable.
Well, see, approach the PHC also and the respondent number 12 also.
You want an interim order today? We are not going to pass that order. We are passing it on Monday.
Because tomorrow is Saturday, my lord. They may
Okay.
again take time. That is what I'm apprehending.
Let the matter be listed on Monday, Lordship. In the meantime, the PHE will be ready to obtain instruction as to
Instruction.
why the connection is not restored.
Lordship, may I suggest Tuesday so that we get one more working day before? Like,
Yes, Monday.
Tomorrow is a working day. We'll walk here, sitting in the chamber. Isn't it?
Monday.
On the prayer of Mr. Borthakur, Learned Council for the PHE department matters and adjourned. You passed in the motion matter, huh? Adjourned. The Mr. Borthakur shall obtain necessary instruction as regards the allegation of the petitioner that her water supply connection, water supply has been disconnected. Full stop. List on Monday.
Lordship, our affidavit is ready,
The
Lordship.
matter will
Now,
come together, Lordship.
And we'll come together. Yes. Duta mein does, one is the orders 60 something, one is motion. So pass the order in motion and pass an order that lists this matter
Admission
on Monday along with benches.
Admission. Lordship.
No, in the motion itself.
Lord.
Both will come in the motion.
Yes, Lord. Oblige.
Lordship,
Yes, Mr. Chaudhary.
Lordship, in this case, our affidavit is ready, Lordship. Today we will file. During the course of the day, we will file, Lordship. In respect to Esplanade 5, Lordship.
So, insofar as the IA is concerned, matter, it was filed day before yesterday. We need a little time to respond to it. Just 3-4 days time.
My lord, the only problem is, what had happened, my learned friend himself made a submission before the court that opening of the, what do you call it, option, a draw block should take place in a couple of months.
No, I
That's-
never.
Yes, it was said.
No.
The recordings will reveal.
Yes.
Recordings will reveal.
Okay.
The expression used just couple of months. Now, my lord, all of a sudden they fixed the date.
When is the date?
No, it is already going. Yesterday it started. The
What
idea was, my lord,
What was this? These
Yes,
are vehicles, the supply of vehicles.
the recordings will reveal, my lord, whether I'm right or wrong.
Okay, what is this?
Now kindly come to page 28.
Page 28 of the
I am.
IA.
Yes. Draw of lots for above said tender will be from 19 to 24.
24th.
Yes, up to 24. So my humble submission is, my lord, this should be state, my lord. When a submission was made before this honorable court by the senior counsel appearing for the respondent, that it will take couple of months, and the idea was during this time, Lordship will hear the matter.
What is the issue here that
What
supply
will
of
happen-
supply
what
of
is-
vehicles?
Yes, what we are saying is, my
New
lord,
vehicles and old vehicles.
no, my lord, it's a new vehicle. This particular tender lacks the essential attributes of a tender. There is no technical qualification, there is no financial qualification, only of draft lot. All that is required is you need to be registered with an employment exchange and you need to be of 18 years and 55 years age. Then vehicles will be allotted. That's the only criteria prescribed.
No age of the vehicle. But
No,
what's it-
age of the vehicle is also not involved.
New, old,
Nothing.
what
But it's a
kind?
new vehicle.
Okay.
New vehicle.
It's
So, my lord,
not supply of vehicles, my lord.
No, understand.
Hiring of,
Hiring.
hiring of
hiring.
taxi.
Hiring of taxi.
Therefore, my lord, in all fairness,
You are excluding.
I'm,
You
no,
are-
no, my lord, we do not know. That stage has not come. I mean, to exclude one.
You are
That-
qualified to participate.
Yes, yes, we are qualified.
What is your apprehension in this
No,
case?
my lord, what had happened? Earlier, there was a litigation before this honorable court, where the authority took a policy decision that one person will get one vehicle. That was put to challenge and that was dismissed. We never had any complaint against that. Now, our case is here, you have introduced a system which is not tender. End of the day, tender means, my lord, there has to be some evaluation. If everything is set in.
What was the earlier when, where you were?
Their policy decision says that they rely upon a tender issued by the Oil India. And Oil India envisages both technical qualification and everything.
What is this then?
Yeah.
This is,
Yeah.
this is, what is this Union of India is, what is this respondents?
Respondents are below.
The authority issued the tender. I thought this is Oil India or something like that. ONGC. So what do you propose today?
Yes.
Doing this one.
Okay, now who filed affidavit? What is the deputy commissioner's role? Okay, oh, that matter, that the local Inclab Zindabad.
Inclab Zindabad.
Okay.
My lord, we are not even gone to that extent because they have excluded only they are permitting only.
Okay, somehow I have
people
also
from
dealt
four
with some
districts.
motion. This is in motion still. Okay, we'll take up this IA next week, any date.
Yes, and they will not go ahead with this.
No, if he is he is pressing the interim order, I'll make my submissions.
No, we'll take it. See, I could not, I was not aware that this will take some time or IA. So I am in fact not prepared. So we are taking up this IA on Monday.
Monday, I'm will
24th is which day?
23rd is Monday.
Your lordship will fix,
24th will be Tuesday.
your lordship will fix it on 25th. In the
But
meantime,
in time that will go, the period will be over.
if he, on the interim prayer, without an affidavit, if your lordship allows me to make my submissions, I can make. There is nothing. 3 rounds of litigations there was no stay. Division bench has refused. Essentially, by way of this IA, they are asking for a review of the earlier interim order passed by my Lord Justice Zotanguma. How can that be permitted?
Who's asking?
Your lordship will.
Therefore,
Your lordship will.
what I
Against the
propose is
refusal
I
of
want to
intent.
take this matter on Monday.
My lord, what had happened?
Monday, I have a matter fixed in Itanagar. So your lordship will have it
My
on
lord,
Wednesday.
when the council makes a submission before the court that we are not going to have the draw of lots for at least.
No,
one-
that submission was never made. Repeatedly, that same thing is being
No, my
repeated.
lord,
No,
it was made. If I'm wrong, my lord,
your
I'll
lordship will
withdraw
see
it.
what submission was made. It is part of the record.
Let the records be called for, my lord, that recording be called for.
We'll call everything on Monday.
Yes.
It is recorded in the division bench order, my lord. Your lordship will come to page 26.
So my only submission. is,
Mr.
my
I.
lord,
Chaudhary, learned senior counsel for the ONGC authorities, has submitted that in pursuance of the NIT, around 27,700 bids have been received, and the respondents are now in the process of scrutinizing the said bids. He, on instructions, has further submitted that the processing of the bids so received, including conduct of lottery for selection of bidders for award of the contract in question, will be completed by 15/10/24. I never said that lottery will start after 2
my
months.
lord, the recordings will reveal whether
Yes,
my
yes.
learned friend made that submission or not.
Yes, yes.
15/10/24.
15/10/24 will complete the entire process. Because the ongoing contracts are till December, we need to give some time to the tenders. That is why we started the process as early as in June. There is a logic. There are 3 rounds of litigations where firstly, writ petition challenging the parent action.
This NIT is under challenge. The parent action, parent policy decision, writ petition dismissed, writ appeal no stay. Thereafter, this NIT challenged, interim order expressly rejected. Thereafter, writ appeal, no interference. Request was made to the learned single judge to dispose of the writ petition by 15/10/24. By way of this IA, essentially a review of the earlier rejection of the interim order is being sought. Is this permissible under the law? That is the question.
My lord, will kindly come to para 6 of the IA, my lord. We have made a statement on oath.
Which means we have committed perjury.
Court, please come to Lord, my lord, someone in the middle. Moreover, the learned counsel for the respondents in reply to a query made by the Honorable Division Bench replied that process needs couple of months for its completion.
Completion.
And therefore, Division Bench was pleased to request the learned single judge to consider the writ petition expeditiously, preferably before 15/10/2024. My lord, let the recording be called for.
Yes.
Then it will be clear.
Yes, let the recordings be called for. I don't even mind.
So till then, my lord, this order should be stayed.
No, in that case, your lordship will hear the IA today. Sir.
Wait for some time.
I guess.
Yes.
Both of us. Let him say, my lord.
Only thing is that actually kind of is that it just said that work order should not be given. But letter of acceptance is not under challenge in this case. It's excise matter. I am the highest paid is more than about 1 crore rupees difference between him and me. And the contract matter, the question of natural justice and all this doesn't come. So see, only one thing from the petitioner side, they have challenged, they are trying to challenge the tender document which is not under challenge in the writ, in the pleading.
No, you're going to marry today, or that's what? That's the thing. I told him outside. There's one date looks 23rd.
I'll only say that if your lordship pleases to make it part.
No, part.
No, 24th is, 23rd is Monday. Monday to issue problem.
July session.
September?
No, October.
October.
Mr. Chaudhary, can we hear your matter on Monday for interim? Where is Mr. I. Chaudhary? It may not be possible. We are in a midst of a part-hard matter is there.
On Monday, he will not be present.
He has argued already.
He is in the.
His whole case is that it will be amount to a review because there is no interim order. On that, we will consider.
And I'll satisfy your lordships in what circumstance the division bench has referred the matter.
Lordship, give us a few minutes. We'll just.
See, otherwise it will be difficult. We will have to adjourn this matter. Then it will prejudice him. If we hear,
difficult.
if we hear it, just call Mr. Chaudhary. Is it not possible? It will not be humanly possible today. Yes, next case. Let us see what can we do. Yes, your matter can wait for when?
23rd.
Huh?
23rd.
3rd is Monday.
No, it's Wednesday.
Wednesday. After
Okay.
opening of the vacation.
After
23rd of October.
Yes.
We are happy. Then we are happy. I thought this 23rd.
Yes.
No, this is not possible.
Our understanding was on your employer is not interested doing within before vacation.
But my lord, what to say, my lord? All the other persons, they have got the license, only me.
Yes, Kokoi.
Non-alcoholic.
Every matter is important. This bench, this is the difficulty.
Because I'm worried, I don't know the taste.
And then so many matters are related, half of them are taken adjournment. We'll have to pass an order ultimately.
No, my lord, what I said, I'm worried because I don't know the taste.
That's why matter is not being taken up. Yes,
Exactly.
that is why, 23rd.
23rd, my lord. There's an interim order, my lord.
My lord,
Interim order is there.
Interim order to continue till then.
my lord, could it,
The subject matter and lawyer is not having that chemistry. Yes, next.
my lord, could it be parted? Only that, so that it can be done urgently.
We do not know whether we'll be here to have a part-heard matter on reopening.
Everybody wants smarter in this.
No, Lord, only so that urgently, because.
No, you may, if we will make an mention. Because it is an urgent matter. Yes.
Lordship, I have an apology, Your Lordship. In item 39, Lordship, there is an interim order.
Okay, interim order 39.
Much obliged, Lord.
Other matters are over.
Minister, if it please. I can have a rati papa for us.
Eking down. Night white yet, home it yet. Yeah, plus not as a long. Then 4 years gonna fall on. Panic over there. Yes.
Lordship, one important fact which
I was, we were at page 188 on last occasion.
Yes,
No, you proceed as per your thing.
Yes, yes.
On last occasion, your sum and
Yes,
substantial.
188, so that was the last page, the minutes of the meeting of 5/9/2020. Now, one very important part, there one argument is that within 10 days of the date of application,
This is one of
the this planning permit was issued. And the flag is on the GMD authorities that they have rushed up the whole thing. Again, my submission will be, if you delay, we get the flag, and now when we do it as per law, we are again on the receiving end.
What is the prescribed
That
provision?
prescribed procedure is Lordship. Lordship will find that.
I think it will be complete to.
Yeah, I'll complete in half an hour, not much. Because the facts, I'm arguing this case on facts only. Guwahati building bylaw, Guwahati building.
What we have understood for your argument is that all throughout, when he was the applicant, he always insisted on the road to be 8.5.
8.5.
8.5.
And he got
always
benefit of 8
insisted,
also.
and initially permission was not granted because the bridge was not there.
Lordship.
So, and earlier those 8.5 has also been given after the bridge was given, and the same calculation was made at that point of time also.
Lordship.
Therefore, the other roads which are measured and reports are given is not relevant subsequent to construction of the bridge. And now it is the road where it is average is 8.5, 4.5, 7.4, and 8 point something.
Lordship.
So at that point of time, the maximum permissible was 200. However, considering the topography of the area, it was given 175. Subsequently, it was an amendment. Height restriction was removed so far relating to 10 plus land, and when 10 plus passed plus 8 plus, then entitled for 275. So therefore, there is no violation.
And if it is beyond 15, it is 300.
It is 300.
So these two new.
This is one aspect of the matter. So therefore, that authority, there is no wrong in granting because they have followed the existing bylaws. This is one part. Second part is so far relating to the bias. When the entire thing was carried on, then the respondent number so and so was not even a minister to influence or to have a bias to allege a bias so far relating to the decision.
Lord.
Now, the third point is the unwanted hurry in from 10 to 19 or something like that.
Yes.
There are some holidays in between, all these are there. So now we'll go to that.
Yes, now, for that lordship will kindly take, lordship, in fact, whatever has fallen for, that is my case.
This is your case.
This
That
is
is
my
how
case.
we have
Yes.
reminded in our.
The parent, the Guwahati Building Construction Regulations Bylaws 2014, which is framed under the Parent Act of 1971.
One month. It was 1985 GMD Act.
That was into 9?
1 month.
Lordship would kindly take the Guwahati Building Construction Regulations Bylaws 2014.
Regulation bylaws 2014. Yes,
Yes, sir.
suppose Advocate General concludes today, then how much, Mr. Pathak, will you address? 15 minutes. Then when will you reply? Today or? Huh? Okay. You are representing respondent. Okay, you will take. Okay, did that. Okay, just just I have in fact summarized his argument. You have taken note. So basically whole contention is to be answered by the GMDA, GMC. They have taken this contention. You have taken note of this. Now, so far relating to the other respondents, it is only the bias. So that we'll hear on that.
So, this Guwahati
But
building.
judgment may be difficult before vacation.
That is lots.
No, why I'm saying
Nobody is in hurry that way.
Because you have seen so many of matters and one bench is shortage.
Yes.
That's why this is the situation. It was not expected. Hopefully from Monday it will change.
And Lordship has noted, so even after 1 month, Lordship will not
No,
forget
in
it.
fact, these arguments I will before vacation arguments I will dictate so that I can take a decision after going through this. This is how I do. First arguments, then after you have to have the before dictation the arguments. And nowadays we have advantages. All these recordings are there.
Recordings are there. So this Guwahati
Hopefully
building,
by next year we'll have the transcription also. Moment it is argued, we'll get a printout from translating from the system.
I saw that practice in UK, London in 2005. Arguments print out, the judge is dictating the order. Immediately in 2 minutes, it is handed over to the lawyers to see if there is any.
It will depend upon you. We have some proposal before the state.
At least 20 years later, we are also
Yes.
at least at the footstep.
At least we hope that it will, at least 5 courts, it will be within this year. Proposals will be there within, we are expecting.
7,000 crores has been given
No,
by the
that is-
central government,
No, that is not for us. This is the difficulty.
Supreme Court.
No, this is for the district judiciary. High court is the responsibility of the state.
There can be some diversions. which the
Therefore,
government always do.
therefore, we are, until and unless a rich states,
Lots.
it is difficult to co-opt with that level.
No, I don't think finance will be an issue, Lordship. And these are not very big amounts.
Yes.
This Guwahati Building Construction Bylaws 2014, if Lordship is pleased to come to Rule 4, Chapter 2.
On a lighter sense, we hope that we don't find any other name in the list. The people sitting behind you,
One gentleman is here, Lordship.
that list.
Well, please, I think one can, his name also may be there.
Okay, then we'll ask them to remove their gowns.
But I did not have the guts to ask that question. Before this court, if he is present, I will ask.
No, don't ask that. No, that not too good. This is in a lighter sense. Yes.
that I will have a stronger team this side, Lordship.
Yes.
No, we have to protect his interest, Lordship, definitely.
Yes, next.
Anyway, Chapter 2, Lordship, form of application, amounts of fees and other particulars required to be submitted with the application.
Because this is
Chapter 2 of Guwahati Building Construction Regulations Bylaws
Just a minute,
2014.
page 13.
Page 13.
Okay, form of application, amount of fees and other particulars.
Procedure to
minute.
be followed, Lordship will kindly come to 8.
Just a minute. Eight. Procedure to be followed.
By GMDA, Guwahati Municipal Corporation, urban local bodies or panchayats as the case may be, subject to separate guidelines issued by government under so and so. GMDA shall verify the zone, road width, floor area, coverage, height of building, parking norms, layout and requirement of external open spaces, other functions as provided in the Act in accordance with the master plan, zoning regulation and the relevant provisions of the Act, rules and bylaws. After verification and making necessary inspection, if the GMDA is satisfied that the proposal conform to the provision of master rule and zoning regulations and the Act, rules and bylaws, the planning permit with the recommendation modification, if any, shall be issued in Form 2. I'm coming to next page now. 9. Inspection and after submission of application. Each application shall be made, each inspection shall be made within 10 days. So where is the hurry? We are mandated to do the inspection. The application was given on 1st. I think on 3rd, the inspection was done. Then 5th, the meeting had taken place. And this is in respect of an existing project. The project, all these minor details, we don't have to go back. Because the original permission was already given in 2019. Again, it was given in 2016, then in 18. 3 times already these records are with us. So when the meeting had taken place on 5th, the application was submitted on 1st. The committee was constituted on 3rd, then inspection only regarding the roads. Then the meeting had taken place and on 10th, we have issued it. The GMDA authority issued the planning permit. So each inspection shall be made within 10 days following receipt of the application. The authority shall determine the plan submitted conform to the requirement of the Act, rules and these bylaws and inform the applicant as per provision serial number so and so. However, if the inspection is delayed beyond 10 days, the applicant shall intimate the authority in writing and the authority shall complete the inspection within 7 days of receipt of such intimation and shall also ensure that the time limit for sanction as prescribed in serial number 13 is strictly maintained. So we cannot delay also. If we delay, then there is a scope of getting deemed permission. That is also there. 13. Time limit for disposal of application. Application for planning permit shall be disposed of within a period of 30 days from the date of receipt of the application. Application for building permit shall be disposed of within a period of 45 days from the date of planning permit. That is the second stage. In the event of failure of the authorities to grant planning permit or the building permit within the period stipulated above, the permit shall be deemed to have been granted and the applicant may proceed with the construction with written intimation to the authority concerned and necessary permit fee to be deposited at least 10 days prior to the commencement of the work, provided that the building shall be constructed as per the provisions of the building bylaws and in no case shall contravene any of the provisions of the regulation of 2010, etc., etc. So there is a time schedule. A timeline has been prescribed under the rules that within 10 days we have to dispose of the first stage, that part inspection, and 30 days if we fail to do it, Lordship, then it is considered to be deemed permissible. So when we are doing it as per time schedule, there is no rashness, no hurry. There are no attribution can be made on the purpose that the act has been done on time. So nothing can be attributed that there is any extra favor or biasness in doing the work which is stipulated and mandated under the regulations. And everywhere the time limit is given regarding occupancy certificate, regarding part occupancy certificates, change of application, every stages. Now, and Lordship, if Lordship remembers, when I read this application, page 188.
Just a minute.
Earlier, always the hard copy is to be submitted. So now, online, that first line, a proposal of group housing residential apartment building
Which
comprising
group you are reading?
page 188
Page 188 of,
88.
of the petition?
Of the affidavit in opposition.
Okay, just a minute. Okay. So we can now close this book or anything will
Yes,
click?
yes, nothing is there. The act also says, this is the rules. The parent act also have the same provision.
What are the sections?
Section 21, 25.
Section 25 of the Act.
Act.
GMC Act.
GMD Act.
GMD Act.
GMD Act প্রথমতে আছে।
সব লাগিব
Permission, section 28 says, 25 says, permission for development. 25(4) says, the authority shall not refuse the permission except on the ground of contravention of proposal contained in the plan or the zoning regulation, and unless the permission has been refused within a period of 1 month from the receipt of the application or such information as may be called for by the authority, it shall be presumed that the permission has been given. So my humble submission is that that whole limbo of argument has no legs to stand, because we are bound to do. And here what I am trying to emphasize in page 188, a proposal of group housing residential apartment building comprising of 5 blocks, etc.
Just a minute.
submitted by Protect Housing was received online. So with technology, just now Lordship has said that arguments, the transcript will come out, the orders will come out. Earlier, all these things would have consumed 10 days, 15 days. There is change of technology. What I am trying to emphasize from reading this now, that the application was submitted online, but as the files were big, so a hard copy was given. And nowadays, for permission to get permission for ground plus 2 buildings, we submit application, we receive, and the online, this application, the permission is granted. No person have to visit the office also. And there are certain guidelines which the timelines are being properly stipulated and prescribed. So if we complete the work in 19 days time, had it been 40 days, let us consider 40 days, would there be any material change? The road will not become wider, neither it will become narrower also. So what attribute can be given, or adverse attribute can be given to the officers if they are working on time? So all this submission, Lordship, in my humble submission, are trying to cloud this honorable court's mind by saying that some extra force is working for grant of this building permission or the planning permission or the no objection certificate. There is no factual basis except saying that a particular date there was a holiday, a Sunday was there. These are normal things. And if we go to the secretariat or GMD nowadays, Lordship, even on Sunday, people are working. The Chief Minister office 24 hours, 3 8 hours batches are there. Nobody is following nowadays that weekdays there will be a holiday, Sunday there will be a holiday. These things are things of the past in for most of the employees. Even if Lordship looks, Lordship's staff, the stenographers, Lordship, they work with Lordship at till 9 o'clock. So can anybody say that beyond 9 o'clock, beyond 5:30, nobody can work? Some of the honorable judges sits beyond 4:45. Till yesterday, one judge was sitting till 6 o'clock. Can you attribute any malice there? It is not, Lordship. Nobody can attribute malice if a person works on time. So these are the changes in the society, Lordship, that on time we don't. And why this concept of giving dim permission? Just to ensure that the public are not adversely affected. They are not harassed.
It is done within a period.
Within a period, if you don't do the dim permission, why that concept has been evolved? It is for
Their time is that earlier was also there.
that dimming was there, but that period was not there. Earlier, I think it was 45
period-
days.
no, no.
Some GMC Act of 19.
There was
2000.
some period,
Yes, Lordship.
45 days or something like that.
45 days
But
was
this,
there.
these details procedures.
These detailed procedures.
There was that application, and if you don't give, then it's deep permission.
And within 10 days, you inspect, within such and such that you give, if you don't, 30 days timeline is there.
Yes, next.
So this, and if Lordship, because I would like, I am not taking the brief of the minister, but one vital aspect I would like to place, paragraph 4 of the affidavit filed by Sri Ashok Singhal, who is respondent number 6. I am not going to the part where his sons are being alleged to be beneficiaries. I am not on that. Only regarding his date of assuming the seat of a minister.
What is the page and paragraph?
Page number 627.
627.
27. Paragraph 4, I would like to read out.
Paragraph 4.
That statements made in paragraph 22 of the instant petition, wherein allegation has been raised that planning permits and NOC issued by GMD and GMC authorities granting FAR 2.75 against the entitlement of 175 or 2 has been possible because the answering deponent's sons are partners of respondent number 5 partnership firm due to his holding the post of Minister of Housing, Urban Affairs and Irrigation with administrative control over GMC and GMD.
Yes, Soduri. It will take, can you do it on Monday? It will take 5 minutes.
My problem is, my lord, Monday and Tuesday.
You ask
Some-
somebody to be here. You have argued, your whole case is that it cannot buy an IA. There cannot be any stay order at this stage when the such same was refused by a single bench, affirmed by a division bench.
That, and on facts, if they open up, even on facts, there was the original policy decision itself was put to challenge. This NIT is a consequence of that policy decision.
That policy was upheld.
That policy was upheld by the London single bench. Appeal, stay refused. That is fine, pending final adjudication in usual course. So where is the question? The lordship will have it on Wednesday.
No, that they see. Okay, can we take a chance today? If Advocate General completes after this.
I'll complete maybe the
Half
other
an hour.
councils, or they will also not take much time. Maybe I'll take in
But
15 minutes, I'll finish.
otherwise, Mr. Chaudhary is taking time to take up this matter. So if we can finish by 4 also.
In 10-15, I will complete.
Okay. Then we'll ask Mr. K.N. Chaudhary will take up this matter. Yes.
So paragraph 4, Lordship.
Multitasking nowadays. Yes.
Wherein allegations has been raised against the planning permit and NOC issued by GMDA, GMC authorities granting 2.75 and against the entitlement of 1.75 or 2.00 has been possible because the answering deponent sons are partners of respondent number 5 partnership firm due to his holding the post of Minister of Housing, Urban Affairs and Irrigation with administrative control over GMC, GMDA. It is most humbly and categorically stated that the deponent had never misused his position to grant any undue favor of the respondent number 5 firm for wrongful gain at any point of time. The most pertinent factual part on the basis of which allegations of misuse of official position by the answering deponent as ministers has been alleged is that the respondent number 5 firm obtained FIR 2.75 as the deponent has abused or misused his power as minister in granting the planning permit number so-and-so 10/9/2020 and GMC's NOC dated 19/9/2020. What is most significant and intriguing is that the answering deponent had become Minister of Department of Housing and Urban Development on 10/5/2021. The other two dates are 10/9/2020 and 19/9/2020. And he became, after about a year, on 10th May 2021. And prior to that, he was not a minister at any point of time, whereas the planning permit and NOC was issued much prior to the answering deponents being appointed as Minister of the Department of Housing and Urban Development. In that view of the matter, the whole allegations made by the writ petitioner that the answering deponent as minister has blatantly misused his position to do undue favor to respondent number 5 for wrongful gain, where both his sons have decisive stakes along with their partners, is wholly misconceived, incorrect, false, malicious, imaginary, and concocted, and it is also an attempt to malign and defame the answering deponent and his family members with malicious intention. In fact, by making such wild allegations, the writ petitioner has misled this honorable court through misrepresentation, and in that view of the matter, this honorable court may be pleased to take appropriate punitive action against the writ petitioner for committing perjury. And repeatedly it has been argued also. So my humble submission is that the concerned minister at that point of time was somebody else, who was at the helm of affairs, somebody else, not this gentleman. Therefore, any favoritism or nepotism cannot be considered. It can be outrightly ruled out. So all the facts are very clear. Whatever has fallen from Lordship, that is what I am trying to emphasize by consuming Lordship's 3 hours time yesterday, that facts should be clear. But the facts were not placed by them. Why they have not placed? Because if they've placed the facts, no case is made out. They got all the benefits on the basis of the road width of 8 or beyond 8 throughout the tenure from 2010 to 2018. In 2019, December or November, and 2020, June, there is a transition. And during that transition, there is a change of law. And the law is changed not only for this particular project, it is for public, general public, and that changes has taken place after long deliberations with various departments, not only of the state, but pan-India considerations, Lordship. So what they have basically submitted, that prayer for quashing of the permit given by GMC, JMDA, in my humble submission, there is no infirmity, illegality to set aside those. Their submission that planning permit dated 10/9/2020, within a span of 10 days, 20-story permission was given. Very nice way they have presented that within period of 10 days, 20-story building is given permission. 100-story building can also be given permission if it fulfills the norms laid down in the act and the rules. For that, no malice can be attributed to against anybody. And 10 days, 25 days, 45 days, these timelines are given in the rules itself. So there is no violation or there is no aberration. What they are saying that on third meeting constituted by respondent number 6. Committee inspected the site on 5th. 6 being Sunday, 7 being Madhav Dev Tithi, 9 being Janmashtami, 10 being permission is granted. Yes. What is the basic thing required here? The basic thing is that the size of the roads. 2 mandals were deputed along with all these members of that high-powered committee, not high-powered committee, a committee constituted for assessing the planning permissions, building permissions, NOC, etc. for projects having more than 10 acres of land.
That point I want a clarification. There is some judgment.
Yes, I'll place. I'll clarify that point also. So, and this is an existing project.
Yes.
This is an existing project. And what they have to examine the building drawings. 3 experts person verified the drawings, tallied it with the requirements under the Act and the various regulations regarding setback, size of the staircase, etc., FAR, etc. To look at that, how long it will take? It will not take much time. On top of that, suppose there is a violation. When the building is completed, there is a scope for inspection, because to issue the occupancy certificate, which is mandated under the regulations, nobody can enter into the building and take possession. If there is any violation, or if there is any deviation from the drawings, everything can be found out at a later stage by the competent persons, competent authority, before issuing the occupancy certificate. That stage till now has not come. Once the project is completed, then the engineer's architect will submit an application before the authority that our project is ready for inspection. Kindly inspect, and if everything is found to be in order, kindly issue the occupancy certificate so that all the gentlemen whose names are there in the list provided by them, they can occupy their respective apartments. So what is the big deal in issuing the planning permit within 10 days? Absolutely no big deal, Lordship. It was a very simple situation. Drawings are ready, figures are ready regarding the width of the roads. They have to match what is prayed and what is there in the records. So that has been done. No civil work is required to be done here. Had there been some civil work or some other special inspection is required, then the things would have been different. Here everything is in order. So in 10 days time, and if they do not do, they have to face a penalty. The officers will definitely have to face a penalty because the applicant will get a deemed permission. So no malice, no mala fide can be attributed in granting the 10 days planning permit. In fact, actually the planning permit is followed by the NOC, by the GMC. The planning permit consists all the particulars, inspection, everything is done. Then GMC issues the NOC. So they will just verify what is there, and if required, they also go and inspect the project. So that was done in another 9 days time. So it is not a thing that some rocket science has to be implemented here. Yes. So this is over. Now another that they have.
That the power of the committee.
That's the power of the committee.
No, they have argued that is what.
Power of the committee, Alice.
They had referred some decision where it has said that this committee.
That committee, that judgment, let us
Authority
see
has been.
whether that committee is this committee said.
That's why we have to verify.
Judgment of court of there. Yes, may I just read and I'll hand it over to his lordship. The instant writ petition, this judgment is of 29/9/2023.
Okay.
This is again, lordship, there is an attempt to mislead this honorable court. 4 years later, some judgment will come before the honorable division bench. And they want the JMD authorities in 2019 or 2020 will contemplate that there will be some changes. What is this? The instant writ petition has been filed by the petitioner challenging the letter memo number so-and-so dated 19/10/2020. A committee was constituted, issued by the Undersecretary Government of Assam, Guwahati Development Department, as well as seeking a direction upon the said high-powered single window clearance committee not to consider the proposal placed before the said committee. So what is put to challenge? 19th October 2020.
Single window committee.
Single window committee. And when was the notification of this planning permit issued? Planning permit was issued on 10th September and the NOC was issued on 19th of September, 1 month prior to this. This committee has nothing to do what has been done by JMD authority in granting the planning.
Is that the same committee?
No,
It was a
absolutely no.
it is a-
No.
it was
This
a
committee has
for-
bypassed all the procedures laid down under the Act and the regulations, which is not contemplated. The specific authorities are there.
So therefore, this according to you, this 20, the committee constituted on 19/10/2020 was a different committee.
Totally different
Totally
committee.
different, and the committee where these 3 persons
Yes.
has examined, it is a for the purpose
For the
of
examining
this.
This and that is still in force. Nobody has challenges. This committee has been constituted for the purpose of verifying all the projects where the land is more than 10 bighas, big projects. May I read the second paragraph? That will clarify. Paragraph 3. From the perusal of the writ petition, it transpires that the petitioners association is agreed by the notification dated 19th April 2020, issued by the Under Secretary to the Government of Assam Guwahati Development Department, where single window clearance committee was constituted with the departmental minister as its chairman. It is the case of the petitioner that the relevant statutes and more particularly Guwahati Building Construction Regulations Act 2010 and its bylaws stipulates that the power to issue the building permit is statutorily conferred upon the JMC, that and therefore the single windows clearance committee so considered is outside the scope of Act of 2010. So it is totally a different concept. That is why we have also decided not to defend this. This was done, which is not there in the Act as well as the regulations.
So then
extraordinary
committee was
minister
constituted
being
beyond the scope with the
beyond the scope, absolutely, Lordship. For that reason, this was set aside. So far as the other
authority was conferred upon this committee to issue this NOC.
exactly, Lordship. It was usurping the power which is given under the
statutory power.
Statutory power has been usurped by the minister.
Statutory power and the prescription.
Yes. That is where the minister would have played a role. And this was not this minister, the earlier minister. So I am giving a copy of this so that their arguments, Lordship may be pleased to handle that part also on the basis of this judgment. My submission is that this committee has nothing to do with the 3 members committee constituted to verify all the particulars relating to any permission sought for from GMDA where the land area is more than 10 bighas. And that committee is still in force. Nobody has challenged it. They have cleared more than 10 projects till now. And some projects are still under their consideration. So they have furnished some chart here giving different widths of all the 3 roads. All the 3 roads which we have also given before this honorable court. The law is well settled that the widest road will be considered for the purpose of grant of FAR and other permissible areas in a building. Then he says, how can the Torunnagar road be considered as the main road? This was one of his submission. How can Torunnagar road can be considered? From day one, all his permissions were granted on the basis of Torunnagar with the assumption that there will be a bridge. Clause number 3 of all those permission of 2010, 2016, till the time the bridge was not made. He got 175 FAR on the basis of the road width of Torunnagar road considered as the main road. So he is taking advantage and he is now questioning only because somebody else is now running the project. How can the Anilnagar road be considered as 12.5 meters road when both the ends are very narrow? One road is actually, there is a dead end. It cannot be considered also. So Anilnagar road.
In the permission, except Torunnagar road, bridge and the road touching the bridge, other roads are not considered.
Not considered. It is not required and it is not permissible also. Yes. If we consider other roads, then he will be the writ petitioner coming this side. Then what will be our defense? Suppose we consider the other 2 roads, then this gentleman will come to this side, file a writ petition, putting a question before this and how will be defended? It will be indefensible case. So at that point of time.
Your case, that is what I have summarized and initially, that the road on the basis of which the present permission is granted was the road which was on the basis of which the permission was granted to the petitioner.
Several times.
From
day one.
Several times. But by virtue and all throughout this has been recommended at many points of time to be more than 8 meters. And by virtue of the change in law, now when it is above 8 and 10 plus bighas, so therefore for that the new added benefit is
Exactly,
granted,
Lord.
not for other reasons.
Not for any other change of law.
Change of law.
What is that change of law? that beyond 8 up to 15 meters,
The
they can
FIR
get
is- FIR includes-
2.25. And if he has project land of more than 10 bighas, then another 50 FAR. That makes it 275. If suppose his land was 9 bighas, he would have got it at 225.
And so far relating to the height of the building, that restriction is no more.
It is not no.
No more.
But the total coverage area,
Because
40%, but he is getting
the
30%.
vertical thing is given according to you for the purpose that it mandates that you will have to keep 40% open area.
Open area.
Open area. Therefore, this can go up.
And what he is doing, he is taking 30.12%. He is not touching 40% also.
This is not their case that.
Now,
40%,
another
30%,
submission. The minister should not have been a part of the committee as his sons were involved. Which committee I want to see from them? Their submission. So they are confusing the single window committee with the 3 members high powered committee. So these are two distinct and separate committees. Whereas the single window with the minister as chairman, that committee is no more in existence because the Honorable Court set aside. Whereas the committee with 3 members, they are technical persons, 2 are town planners and 1 is the architect. They are still doing their job. And nobody till date has challenged that committee. Legitimacy of the 3 members committee is to be questioned to fellow ministers and project committee cannot be formed. So that committee first you will have to challenge. Where is the challenge? Unless you challenge, will not defend it. First, you raise the question. Only making oral submission will not do. He has, for umpteen number of times, submitted RTI applications before us. All the figures which the Protect Group did not disclose to Megmola Lordship, we have disclosed it. What is the FIR? What are the calculations? So he could have got this, how this committee was constituted, what are the file notes, what was the reason this committee, what functions they are delivering. All these things can be challenged. But first you have to challenge, then to say that that committee is bad. So as and when that committee is put to challenge, we'll definitely respond to that. So they are saying that public law element. Yes, public law element, we are strictly and without any deviation, we are following it. We are not giving them 300 FIR. Neither we are giving them 175. They are entitled for 275, so they got 275. In fact, they can now charge us. On what basis we have given them 274? In fact, a case is made in favor of them. Why? In spite of having 8.3534 meters of road width, we have restricted their FAR at 274, if I'm not wrong. 274. So 1 is reduced. They are entitled for 1 more also. So whatever may be the reason, the committee has taken a call. When it will be challenged, then we'll disclose the reason why 1 point is reduced. But we cannot, as per his choice, make it 175. If you had made 175 by acceding to his prayer lordship, then in my humble submission, it would have been very difficult for me as a council of JMC and JMD to defend that decision. Now it is easier for me because everything is in terms of the letter and spirit of the Act and the regulations.
Yes.
So judgment they have relied upon 1965 SCC. There cannot be any waiver for fundamental right. I am not saying they are waiving fundamental right. I am saying, Lordship, that what fundamental right has been infringed. Magmolar got 200 FAR. Protect got 275 FAR. There are certain situations. They could tomorrow, with the change of law, if the project is not completed, then they can get 500 FAR also. By that, what private right or what fundamental right of the writ petitioner is infringed upon? It's very difficult to accept that submission, Lordship, because no fundamental right. What I am getting, if you are entitled to get, and you are not given, then fundamental right will be infringed. He will be prejudiced. But in the case, somebody else is getting on the basis of his credentials, He is getting it. Had it been a public interest litigation, I would have understood that the local area people, the overall ecology, the whole ecosystem would get some difficulty. That because of this high-rise building or maybe widening of the road, etc., there is some elements of public grievance. In that case, a proper forum would have been to file a public interest litigation. Here it is abundantly clear that two clauses of the MOU and the deed of agreement is creating the problem. The communications which they have annexed clearly discloses before this honorable court. Any person with minimum common sense will also understand that there is some communication between these two parties. They want more affair. They are not ready to give affair because the clauses are there. If they have any grievance regarding those clauses, this is again not the right forum. These are private disputes between two parties.
Apparently, this is, it will be, to summarize, to frame frame your argument that, okay, he can come to the court alleging violation of fundamental right, but when the permission is granted in terms of the GMD Act and rules, no right has been violated. Rather, it is a private dispute.
Private dispute. Here.
So suppose in a situation, what they are contending is that, okay, by violating, by constructing in violation of the bylaws and all, this is their case. So therefore, I have a building there, say suppose for 35%. So it will be an illegal building. So therefore, I have a right. So that right will depend upon whether the permission per se is held to be as per bylaw or not as per bylaw. If it is as per bylaw, they cannot have any grievance. This is your...
No, my argument is something different. Yes. I am challenging his locus.
Okay.
His locus here is abundantly clear that he is not happy with those two clauses of the agreements between these two parties. And they are trying to use this honorable court as well as putting pressure on GMC and GMDA to reap some benefit and get some better bargaining power with the other party.
So you want to say that the writ petition is filed not for violation of any fundamental or any other legal right, but for an oblique purpose of putting the other party in pressure to concede to his claim.
Absolutely.
This is okay.
Spot on.
Yes.
So his locus in this writ petition, I am submitting, Lordship, is not maintainable.
Because according to he is not having a locus standi for the reason that the dispute between them has already been settled and converted into a written argument by the memorandum of settlement dated.
Exactly.
And any dispute arising out of that can be decided by a private forum or by the civil court.
Arbitration clause is also there. So now, if his private right is to be violated, or if his private right or this fundamental right is being infringed, all this action, what is that action? Giving him more affair. Irrespective of the status, whether he gets more or less affair, that has nothing to do with the
permission,
with the fundamental right problem. That is not contemplated under Chapter 3 of the Constitution of India.
Yes.
That is not fundamental right. Maybe he can be aggrieved, but that aggrievement will be result out of private right. Private right, not fundamental right. There is a difference between fundamental right and private right. And private rights are not straightway protected by the Chapter 3 of the Constitution, in which case Article 226 can be invoked in the form of a writ proceedings.
Yes.
So he has not been affected adversely by any action of GMDA or GMCA while issuing the FAR 275 to the other party.
Yes.
He is directly interested in the FAR bargaining business here. So my humble submission, no fundamental right has been infringed upon, and therefore this writ petition is not maintainable. some very vital facts. One document. When he comes before this honorable court, he has to come with all his materials.
So suppression of material fact that you have argued that.
Yes, in support, I will place a judgment.
That
Later he submitted before the deputy commissioner in the hearing.
Was not part of it. Then the whole committee report, the deputy commissioner's whole report was not there. Only one part was three pages were there.
Agreement,
And the
deed of
memorandum
agreement.
settlement was not part of this. That was subsequently MOU or something like that.
MOU he annexed, but the other one, deed of agreement.
Deed of agreement, settlement.
6-6. That is not submitted. Even if he have deliberately or indeliberately or inadvertently missed out the deed of agreement of 6-6. What about his main document on the basis of which he participated in the hearing before the authority?
And asserted that it is 8.5.
8.5. Whereas he is time and again harping that GMD and JMC is suppressing and not considering the report submitted before this honorable court and the DC of 2013 report. He says that we have not considered while granting the planning permit as well as the NOC in 2019.
The 2013 report.
2013, we did not consider. We have considered because everything was part of the record. Whereas he disclosed his letter before this honorable court or not.
That I have recorded already, suppressed.
He has also just given a whisper that he got 200 FIR in 2018, but he has not annexed that document also. Deliberately, he has tried to project a case that on a road where the width is less than 8, we have given more FIR. All his documents in various paragraphs of the writ proceedings, in the pleadings, I have indicated yesterday itself, in various paragraphs as well as those letters before at the time of hearing, he has given different figures regarding the width of the same road. Although in some cases, he said it is less than 8, but all along he got the benefit as 8 or beyond 8. So his whole intention is clouded. He is not before this honorable court with a clean hand and clean mind. In support of my submission, also I'd like to place one judgment. 1997 1 GLT page 68. Division bench judgment, State of Assam versus
1 GLT page
1997 1 GLT page 638.
638.
State of Assam versus Godon Chandra Dihingia, paragraph 8.
Yes.
Apart from the delay and laches on the part of the petitioner, suppression of material fact was by itself enough to disentitle him from claiming any relief from this court. In exercise of his jurisdiction, a candid disclosure of all material facts by the petitioner is a sine qua non for invoking writ proceedings. And another judgment, Income Tax Officer Dimapur versus SS Ahluwalia, 1997 2 GLT page 199, paragraph 14 and 15.
Page 199.
199. Paragraph 14 and 15.
Yes.
Paragraph 14, in the writ jurisdiction under Article 226 of the Constitution is essential and equitable jurisdiction and has been pointed out by the Apex Court in one of its recent pronouncement in K.R. Srinivas versus R.M. Premchand, 1994, 6 SCC page 620. A writ petitioner must come not only with clean hands, but along with clean heart, clean mind, and clean objective while coming to the court for relief in public interest litigation. In the same vein, J.S. Patil versus so-and-so, it has been highlighted that a person who does not approach the court with clean hands cannot seek equity.
Yes.
These two judgments I am submitting, Lordship. Yes. And on top of that, his whole case and whole argument day before yesterday was revolving around that the minister has utilized his power, exercised his power for benefiting Protect, where his two sons are partners. all the events had taken place much before he became a minister. This gentleman became minister on 10th of May 2021, and the impugned NOC as well as the impugned planning permit was dated 10/9/2020 and 19/9/2020. So in that view of the matter, that whole argument, it has nothing but it has already crumbled with the facts, and I'm sure they will not be able to give a counter that this gentleman became minister when these events had taken place. What are the events? The changeover of the project promoters and the issuance of the fresh planning permit as well as the NOC. So in that view of the matter, in my humble submission, this whole writ petition is totally misconceived, without any locus, without actually giving the correct facts. Whatever facts, it is very clearly discernible that on the basis of the same credentials, same parameters, same measurements, he obtained all the benefits, and when the same benefit was given to the other side, as per the existing law, he is aggrieved. So nothing is there, Lordship. This petition does not have any merit, and therefore it is a fit case for not only dismissal, Lordship, in my humble submission. They have to be penalized with imposing a massive penalty. This is my humble submission. I am deeply obliged. And the relevant clauses, Lordship, yesterday, Lordship was pleased to, regarding the road, when that, it are already quoted in the minutes. Yes. So if anything, Lordship, my friend will be here, he will clarify, if anything. I am also here, Lordship. Yes. So I am deeply obliged for patient hearing and giving us ample opportunity to project our case. Highly obliged.
Yes, Pathak.
May it please.
Yes.
I'll
You are for
response number 5.
Response number 5, the minister.
No, I'm for that.
Protect.
Protect.
Okay.
Mr. Gunga.
Anything to be added?
My lord, little, because there are two facets of the entire problem.
Okay.
First, what is their relief? I'll just summarize because I have already prepared a 2-page note on what exactly is their problem. Page 24 and 25. My lord, I have prepared a small, if I can see.
Yes, Mr. Chaudhary. Multifaceted, multitasking. What is to be done? Where is Mr. Ken Chaudhary? We can hear you. Keep their thing for Monday. Huh?
I will just place the facts and what is the position.
Then we can do it. If you can finish 10-15 minutes.
Yes, yes. It should not even take that much.
If we
10 minutes is
accept,
good.
reject whatsoever, but since they have pressed, we think we should not shy away from
Absolutely.
it.
And my difficulty is not that these are two matters I simply cannot avoid. Challenging of, in fact, my lord had the occasion to fix one of them. Yeah, in your lordship's last visit.
Okay.
Challenge to that.
So, okay, we'll hear you today. Keep somebody.
Yes, sir.
Multitasking now.
My lord, I only accept this problem. My lord, I'll keep this on record. I prepared a small 2-page note, exactly what is their problem, besides me. Not difficult, because too long a note will not. Well, before
My habit is shorter things always.
that is actually good. My lord, if I make another repetition out of it, then there will be nothing left. My lord, the whole thing is like this. I just checked up what they exactly want. For that, I looked into their relief. In relief, they have 2 prayers. First prayer, they say that 275 should not be given to me. It should be made It's a categorical statement in page 25. It should be made 175. And second prayer is that construction permit given by the GMC should also be satisfied. These are the two prayers. Now, so far, the genesis of this litigation as per them starts from 2009, 2010. On an application made by them in 2009, they got 175 FIR. And they say that we should have been given 200. As Learned Advocate General has, I will not go into it, elaborately stated from the records that this particular permission, FIR of 175, was conditional. That you make this Bhorolu bridge. But it was unfortunate for them that issue of Bhorolu bridge construction went into a litigation. And that litigation continued for some time. Eventually, the Bhorolu bridge was constructed, completion was done in 2017. I'm coming slowly because at that stage I was not there in the picture. After the Bhorolu bridge was constructed, now since it was a conditional, they apply, precisely I will tell the dates, my lord, they apply for 200 FIR. Now, since they have to get, because of the Bhorolu bridge, they were not getting, they were given 200 FIR. Now, as the ill luck was, after 1 year, that was from 2018, they got it, 2019, they ran into a financial difficulty. And they approached us. At the time of initial hearing, it was stated, we never ran into financial difficulties. But that is actually belied from the fact that they entered into an MOU, and the recital itself, they said, we are in financial hardship.
Because it is to pay to this bank
and
what is and some payment was made. These are I do not think they are disputing because they
now,
themselves
yes,
just
they cannot now. The consideration of that MOU was that you give me 23 crores upfront and another 11 crores
to bank.
Yes. Now
and 35% share.
35% share. I am happy. Now we entered into an MOU because they additionally agreed as a consideration for giving us this, that if you get any additional FIR in any future loss, we will not have any share in the profit. This is in writing. I will come into it. Number one. And number two, they said, apart from.
You say that all 30% will be on the basis of the permission FIR, what you have got, not that we may get.
We may get under an existing law. 2019, they entered into an MOU was. Now, what happened thereafter? We gave them 11 crores and all this, 23 crores outstanding liability. Now, in 2020, your lordship will see the date. On 5th of May 2020, next page, my lord.
Yes.
GMDA bylaw of 2020 was gazetted. 5th of May is very important, my lord. Now, writ petitioner chooses not to rescind the MOU. That was still an opportunity for them that this is we rescind the MOU, take back your money, we rescind it now because it was an MOU stage. They go forward, the lordship will see the date, 6th of June 2020. They enter into a registered agreement with us. They make it more solidified. And the registered agreement, I'm sorry, Mel, it is not 5-6, on 9/11/2019. Now, there are few pages that draws my attention. Page 143, agreement is based on writ petitioner's 218 permission for 200 FR.
That I have said only.
My lord. Page number 148, calculations of our sharing profit and we giving money are all based on 200 FR. They have taken the money on 200 FR. Now, why I'm saying so, I will take your lordship after some time. What is their prayer? Now they want me push back 175. They have got the money on calculating 200 FR. Now they made a writ petition prayer that it should be made 175. Now I will come into it. Page 154, assurance of the writ petitioner that R5, I am R5, my lord. can apply for many more FR if permitted by law. That clause also I have mentioned.
That we already noted down.
Noted the mark because Learned Advocate General elaborately. Page 155, registered agreement based on writ petitioner's 2018 permission. Had it been MOU, there could have been argument. You have yourself registered.
MOU was preliminary to finalize the modalities, that this is the kind of a process things. We'll finalize all these things and we'll have a complete settlement by way of a registered agreement. That was provided in the first
And they
MOU
took the
itself.
money.
Yes.
And now they push me back, want to push me back by a prayer, first prayer, my lord, 175. Now page 157 is the arbitration clause. Now here after some time, my lord, I will take 2 minutes more. There are two, as I.
Yes.
There are two facets of the entire problem if I appear for them. Either they have a problem with the government for the bylaw or for the permission. And or they have or both. They have a problem with me regarding my agreement with them. There are two avenues open to them now. Now, with the permission of the High Court, with the approval of the High Court, I'm sorry. With the approval of the High Court, the appellate authority under Section 71 is constituted. If they have a problem regarding the permission, and if they have a problem regarding me, I do not know which, because from the writ petition, it took long time for me to understand what is their case about. If alternatively, I think if they have a problem regarding me, they themselves have a registered agreement for arbitration. I do not know which way they want to select. Now, to avoid both the alternatives, they have gone for 226, want to push me back to 175. Now, 10/9/2020, on an application made by me, R5 gets 275. Learned Advocate General has already in Threadbare has discussed how I get. If I add one more sentence to Learned Advocate General's submission, it is not only GMDA, most probably it is bylaw 8. Bylaw 8. After GMDA does their homework, before giving up the construction, GMC is forwarded with these copies by the GMD in 3 sets. And GMCA does an independent exercise. May I draw your lordship's kind attention? Yes. This particular provision, there is not a whisper from them that this is violated. Bylaw 8, first 3 and 4 only. There is not a single whisper subject to correction. I have gone through it 3-4 times, the entire writ petition. What is the basis for cancellation of the permit?
Okay.
3 and 4.
3 and 4.
And subject to correction by my learned colleague, there is not a single whisper that there is a violation of clause 3, clause 4. Yes, lordship, that.
Yes.
So, with this factual background, I have 5 submissions. First is submissions on relief sought for no challenge to the bylaw. I could have understood, even Learned Advocate General also has submitted. If you have not prayed for a relief, the issue or any debate on granting of it does not arise. Submission of alternative remedy. My lord, that notification complete, if your lordship permits. High Court has given the approval for constituting. I am not sure exactly against whom they have the problem. If they have the problem against the government, this is the advocate general there. Last sentence, my lord.
Okay.
Now-
Appellate authority.
Now, I presume because in their submission, I heard that they are attacking the government as well on the permission. If it is so, then with the approval of the High Court, there is a specific appellate authority framed under Section 71 of the Act.
Yes.
And if it is me, I am not sure, my lord, exactly, I am confused with the entire pleadings. If it is me, then they are bound by the clause of arbitration.
Yes.
Now, submission of on Estoppel. Oh, thank you. I'm told arbitration is at the argument stage.
No, that Mr. Chaudhary has submitted. He said that so far relating to claim and all, I have gone to the arbitration and that he has already submitted.
Right. If they have submitted, but arbitration, if he has dispute with me, because writ petition is not vague, very vague about it, that against whom, if it is against the learned advocate general's client, that's on a different footing.
Basically, it is against the state in granting the state means EMDA in granting the permission on the ground that this permission could not have been granted in that area on the basis of the road width. And he raises some proposes that these are the road width,
May I add
which has been answered by.
May I add one sentence?
Yes.
That means I take it from the pleadings that he is not aggrieved by the bylaw.
No, there is not aggrieved by the bylaw.
He is aggrieved by the procedure.
He is aggrieved by the fact, according to him, that the permission has been granted in derogation of the bylaw.
Bylaw. That means bylaw, most probably he wants to say, because all these paragraphs are.
He is on his case is that, okay, bylaw, there is no, he's not challenged anything of the bylaw, but says that he's not saying that road height should be maximum, minimum, or what's this prescribed. He says that road width is not there. You have wrongly given.
This is factual determination. For that, there is an authority constituted by the High Court.
And Advocate General says even we are ready to have a measured in presence of it through even by an advocate commission.
But the mandate of the law, if you
that is what they have submitted.
if you are aggrieved on the factual side, that this should be 2 meters more, 2 meters long, length should be this. He should not have invoked 226, gone to the appellate authority under section 71, authority already there sitting.
Yes.
If it, I do not know, pleadings is not cut. I do not know from the pleadings. Now, why I am third point about this sale agreements with FIR is 275, he has already acknowledged. Subsequent to the completion of the project, I have entered in, not I, the Protec has entered into an agreement. One of them or few of them are from our profession as well. That they say, anyway, because it may be doctors, it may be advocates, that I have noticed some advocates are also there.
Yes.
Now,
We have many other doubt. Anyway.
My lord.
Yes.
Now, he says.
Looking at the anxieties.
My lord.
Yes.
Those sale agreements, if your lordship, if I can tell on page number 217 of the writ petition, sale agreements are endorsed by the writ petitioner as a party to the sale agreements. And sale agreement is based on 275. And it specifically says about 2020 FR of 275. He has acknowledged all the signatures are there. Now, having acknowledged it and saying that it is on basis of 2020, now before this honorable court, can he say that it should not be 20? Then if he says so, then all the parties, might be many of them are advocates, they have to also make parties.
Do you propose to say that they will have to remove their
I do
government
not mean any of
stand here?
them. I do not name anyone, my lord. Now.
Yes. Yes. These are on lighter.
Might be instead of Mr. Das, Learned Advocate General, Mr. Deka, I would have many on the right side. Now, and she is having taken the benefits, petitioner is stopped from doing this. Arbitration clause, that I have already explained, he should come with clear pleadings. I am aggrieved by government, then I do not have anything to do. I am aggrieved by Mr. Pathak's client. I have nothing. Then arbitration, if it is against me, arbitration clause is here. And the scope of arbitration is quite large in that clause. Anything you can have. You can have in one whole arbitration, you can have a specific issue arbitration. Submission outside pleadings. In the first round of in the first round of argument, I heard him specifically. How can they get so many the floors, additional floors? What I have got, they should also get. Without even keeping in mind the law had changed, number one. Number two, that how can he do, how can I could not do it? These are for not the court to examine it. Whether it conforms to the law, if it is so, and
That is our limited exercise to
My
that
lord.
extent, that's all.
only some kind of high sounding words that how can he go creating some suspicion here, everywhere. Now, wrongful gain, my lord, it is very clear in one letter, page 558.
Page?
For what purpose he has filed, page 558.
That page, I have seen it.
I will not name to whom it has been addressed. My lord will skip the first page.
Yes.
559, last page. I will not read out the file.
558.
It starts.
Okay.
Written by the last portion. Clause 3.
Just a minute.
559.
559. Okay. Yes.
Clause 3, my lord.
Yes.
In the light of our resolve not to demand any share of the extra FR, they are not demand. Even if they demand, they won't get anything. We request that clause number so-and-so, which reduce the area of super built-up area to so-and-so, from so-and-so, should be deleted. And now, sub plus, sir, should protect, delay the settlement of any time now. We will proceed with our litigation as applicable. We have already taken appropriate steps to give wide publicities through electronic, newspaper, and social media platform, besides political channels, to expose, protect misdeeds. And now he says, if you don't settle with us, we will do this. And this is what is written to an arbitrator. He was at the level of an arbitration. Conciliator, I'm sorry, conciliator. A letter was written to the conciliator with a copy mark.
Okay.
Huh? My lord will kindly see page number 226.
Page
226 actually. He didn't call me confirming parties. Oh, page number 226 in the sale deed. What is he is impugning, he is confirming.
Page 226 of the page 226.
That sale deed. Agreement with the flat buyers. For at that stage, while confirming this, it is
226 clause.
Clause Roman 4. Roman. I don't know. 10-9-2020 has a lot of got it. It is impugn notification. I mean, impugn permission, he confirms it as in the sale deed. He himself confirms it.
What sale deed is this?
Sale deed to the flat buyers.
Agreement for sale or sell it.
The people who ultimately remain, not that extra portion, earlier.
To understand, his earlier client.
Earlier client.
His earlier clients with him, he had
confirmed
an
that
agreement
2020.
because he has declared that there may be pressure and money is to be repaid back to them also. So this is one of the sale deed or agreement for sale?
Agreement for sale.
Okay, okay.
He is a confirming party. His signature is there. Your lordship will look at page 217.
200?
Page 217. Magmolar Estates Private Limited. As your lordship. Page 217 starts. 217. Magmolar and Messrs. Magmolar. As your lordship.
Yes.
There he confirms to the flat buyers
So this is a tripartite agreement.
between
Okay.
flat buyers.
Yes.
Now, my last submission was wrongful gain that your and writ petitioner seeks to cause wrongful loss. Reference 19(4) of the a building নাম কি আছিল ৰেৰাখন?
Real estate regulation and.
Section 19, it is stated, he knows it, that if there is a delay in completion, I need to pay compensation plus this much of interest. In addition to this, being that he pressurized for in the nature of an injunction, to stop them. 19(4) language, my lord, RERA Act, Real Estate Regulation and Development Act, 2016.
Section?
Section 19, subsection 4. I am liable for compensation now.
Yes.
Since I am not sharing with him the extra FIR, now he wants to see that in Assamese there is a question that Nijor Nakkati Hotini Jatra Bhango. Ultimately, if it is done, the original flat buyers will also lose.
But this may be a case, if you give that example, Apunar Nakati have your own benefit, not Hotini Jatra.
My lord, Apunar Nakkati having your own benefit.
That can be your argument. Yes.
Yes, my lord. Alternative will be to follow. My lord, may I have the indulgence to put it on record, this synopsis?
That is, I am.
I'm obliged, my lord.
Okay.
That's 5 minutes. Why have been dragged like on? And I will, my learned advocate general said, cost has to be imposed. I think cost has to be imposed for dragging me in this court. Paragraph 22 of the writ petition. That's the whole
Just a minute.
contention against me. Kindly see para 22. Just come.
Mr. Pathak is appearing for R5. Yes.
We are appealing for 2 minutes.
Yes.
Respond number
Paragraph?
6. I'm
You are
appealing-
for? You are
I'm
for?
the minister. Respond number 6.
Respond R6.
Initially not made
Made
a
a party
party,
subsequent.
subsequently made a party.
Paragraph
Paragraph 22.
of the writ petition.
Yes, page 20
Yes.
and paragraph 24. These are the two paragraphs. Allah will kindly look into. Where is my- Affidavit. My lord, paragraph 22. One paragraph.
Page
Page 20.
20. Yes.
That the petitioner respectfully begs to state that so far as the legal wrong which has been caused to the petitioner for entering into MOU dated 9/11/2019 and a deed of agreement dated 6/6/2020, petitioner will pursue his legal remedy approved. However, the present petition has been instituted to redress the grievances arising out of a planning permit and NOC issued by GMD and
Paragraph
GMC.
22, na?
Paragraph 22.
Yes.
However, your lordship will kindly
Yes,
note
however,
down, present period has been instituted to redress the grievance arising on a planning permit, NOC issued by GMD and UNICEF. Pausing for a moment. Your lordship has noted down that the application for GMD planning permit was on 1/9/2020. And the permission which was granted by the NOC, which is in 19/9/2020. What is evident from the fact narrated in the preceding paragraph, respond number 5 in collision with GMD authority managed to get FAR of 2.75, when in law the entitlement is only 1.75 or at best 2.00. This has become possible because nowadays so and so who are partners of respond number 5 partnership firm are son of Ashok Singhal, who is a minister of Housing, Urban Affairs and Irrigation, Administrative Ministry of both GMD and GMC. It is a specific contention of petitioner. It is a unique case where a minister has blatantly misused his position to undue favor to respond number 5 for wrongful gain, where both his sons have decisive stakes
along with their partner Manoj Kumar Jalan. It is worth mentioning that because the enhanced FAR, the response number 5 stands to gain approximately 2.5 lakhs per so and so and so. So apparently it appears their statement is that the present minister, this Ashok Singhal has become he was a minister. So his son got the benefited of this extra
Two
FAR.
contention. One is that he was the minister and he misused the position for wrongful gain of his two sons, as he was the he has the control over the GMD by statutory.
Now to give an answer, my answer is that the permission which was granted and a planning permit was much more prior than he became a minister. I think the AG has also addressed, and that is our response, which is your lordship, which you read my affidavit.
tell your
Yes,
paragraph of affidavit.
yes, paragraph 4. Paragraph 4
of
paragraph
affidavit of
4
R6.
R6 to the page 627.
620. That we have already okay.
Yes, 627 to their affidavit, their petition, paragraph 22. That's our reply. That's our reply.
That is what is required.
So now, my lord, they cannot say I have misused. Misuse would be if I would have been a minister. I was not minister. Minister was subsequently. So there is no question that misusing the power of a minister because these two sons were there. So they have got the permission. That 2.75. So that's my humble submission. That is not tenable. And my lord, unless this minister has been dragged in this particular case. Unless he has been dragged. And when they know that they doesn't succeed with that, then I think they have bought certain allegation regarding formation of a committee. Now that reply my learned friend AG has given to your lordship, what is committee? It has been constituted under the provision of the act. And the judgment which I was just hearing it, that doesn't have any relevance because of 2023. So my humble submission is unnecessary. I have been dragged in this particular case. This paragraph 22, which they have brought into it, that should not be taken into consideration, my lord. That's my case, my lord.
When? Monday or okay, let me finish it off. When? Monday is not possible. This Monday.
Yes, lordship. Or when is the lordship?
This Monday may be possible. Monday may be possible. How many matters fixed? 20. Okay. We'll complete on Monday.
Yes, lordship.
This will not be required anymore.
He will be somewhere else.
No, I don't know whether I'll be here or other court.
We do not require your presence until and unless there is necessity for you to be present.
Apparently, it appears. That may not be necessary. Apparently, it
It is a
appears.
special privilege for Mr. Das, madam.
It may not.
Can also be excused on Monday.
No, we have no problem until and unless you want to.
My lord.
You are most welcome.
My lord.
The learned counsels for the respondents has concluded their arguments. Full stop. List this matter for reply argument of Mr. K.N. Chaudhary, learned senior counsel on Monday.
Monday. On Monday, my lord, lordship can have it in the second half. I'll take.
No, after completing the
Yes.
list, hopefully Monday situation will be improved because another bench will be available for bench 4. Otherwise, this bench is taking the bench 4 and 5 both. That's why we think we'll be able to by sleep.
Yes. Now, just to briefly indicate the case, Millard, I'll just take 5 minutes time. Now, why I'm saying, Millard, this is not a tender. Millard, the other day I gave
Just
one.
bird's eye view, what was the issue? Just because I have not gone
Very
through.
simple, Millard.
I have not gone through the.
The ONGC wants to hire vehicle. And we are the persons, my lord, normally who are in this business. In fact, some of our vehicles are
under contract with the ONGC, and our contract is valid up to December, na? So it's going on. Now a tender has been issued, where in our humble comprehension, the basic elements of tenders are not there.
Okay.
Now, why I'm saying so, well, on last occasion I gave the judgment whether it is on record at a copy to the appeal.
There is a judgment, Michigan rubber.
Yes, please come to page 229, my lord.
Place 229.
Yes. Please come to subpara D of para 23.
Just a minute, 229.
Yes.
Okay, subpara.
D, small d of para 23. Certain preconditions or qualifications for tender have to be laid down to ensure that the contractor has capacity and resources to successfully execute the work. So, my lord, having regard to this pronouncement, let us test the present tender. Now, my lord will kindly come to the tender. Please come to page 46.
Just a minute. Too many judgments. Why earlier hard or what?
I'll rely on only one judgment.
No, there are many judgments in the file. We are on repetition or IA?
I'll have to, naturally, I'll have to throw some light on the facts also.
Or therefore, which record?
In the IA, we have brought on record only that.
No, just we'll see. Your argument from the repetition. Okay, yes, that is what it is.
Yes. Page 46.
Yes.
Now kindly see the tender, so and so, hiring of services of brand new 372 number of light vehicles for Assam Asset for a period of 4 years on lottery basis. Number of categories, 6 categories. Category 1, Mahindra and Mahindra Bolero, 278 numbers. Category 2, Mahindra and Mahindra Bolero 4, 28 numbers. Category 3, Tata Yodha pickup, 45 numbers. Number 4, Toyota Innova Krista, 1 number. Category 5, Maruti Dzire, 3 number. Category 6, Mahindra and Mahindra Scorpio Classic, 17 numbers. These are the 372 number of light vehicles which are on the offer. Now, my lord will kindly come to page 47.
Yes, page 47.
Yes. Draw of lots. Against the current requirement of 370 vehicle under the tender, a total of 500 applicants will be selected by the first round of draw of lots. The first 372 would be ranked as the shortlisted applicants, and the rest 373 to 500 subsequently ranked as waitlisted applicant category wise. So first 372 would be there, then the balance would be up to 500 would be waitlisted. Now please come to next page, 48. Now my lord, these are the category of vehicles. Then my lord will kindly come to page number 51. Please come to the bottom, my lord, 2.2. On login to the application system and after verification of the registered email ID and mobile number, the applicant shall enter the following detail, name, etc. And amongst others, my lord, this employment exchange registration number at page 51 towards the bottom. Then valid date of so-and-so, date of birth. Then please come to the last one. Applicants falling under 18 to 55 years on the tender original closing date will only be allowed to participate. So what we find, my lord, subject to correction, there are 2 criteria. One must be registered in employment exchange and applicants should be within the age group of 18 to 55 years. Then my lord will kindly come to page number 53. on top, lordships will notice only individual belonging to Sipsagar, Nazira, Sonari and Moran can apply. Anyway, that though this is illegal, my lord, though unconstitutional, we are not laying a challenge to that. Then my lord will kindly come to page number 55. Towards the bottom F.
Just a minute, 22. Then.
Page 55. Towards the bottom, clause F. Draw of lots will be held on the specified date mentioned in para 1.1 above at this
Clause,
resource
page 55 clause,
last miller towards the bottom F, small f.
a small f.
Draw of lots will be held on the date specified. Then my lord will kindly come to page number 57. Anyway, this is not very relevant. Then my lord will kindly come to page 108.
Yes.
Notes. The offered light vehicle taxis should be brand new vehicle with so and so, so and so. With all standard fittings and accessories as per the manufacturer's latest leaflet and meeting the latest government regulation and tender specification, purchased and registered after the date of issue of NOA for commercial use for activity of oil and natural gas corporation.
What is NOA?
Notice of notification of award.
Okay.
Then my lord will kindly come to
Award,
109
after award, they will have to purchase it.
and 109.
109.
Yes. Now there are two category of vehicles. Self-driven, light vehicles shall be driven by owner himself throughout the contract period. Owner has to give written undertaking that if at any stage it is found that the vehicle is being driven by some other driver, the contract shall be terminated with immediate effect. Then ownership, this is the other category. Light vehicle have been awarded to contractor. Contractor may hire another driver for driving vehicles. The distinction being in case of self-driven, the owner himself will have to drive. Under any circumstances, he cannot engage a driver. And category B is the owner. Now, my lord, I pose a question to myself. Now, which is that competitive element in this tender? Supposing, my lord, two person vie for this, for a particular, offering a vehicle. Now, how will you judge between the two who should be, preferred? So therefore, my lord, now my learned friend was referring to another writ petition. In that writ petition, my lord, challenge was laid to the policy.
Policy of this drop lot.
Policy of one applicant, one vehicle. So we are not agreed by that. Our case is, how come you are going to select the awardees?
It should not be drop lots.
Yes, should not be drop lots. Instead,
It
there
should
should
be,
be
there is some specification, qualification criteria so that
experience,
there is something
That's
in
the
there.
only case.
This is your case. Okay.
This argument was not appreciated by the learned single judge. Therefore, interim order was not given. Then we approached the writ appellate court. Now, writ appellate court noticed that the matter is fixed on such and such that it was in that view of the matter, said, we'll request the learned single judge to dispose of the matter. That is how the matter is before lordships. In the meantime, this development has happened, whereby this date of draw of lot has been notified. Because the argument made before the court was, it will take couple of months. I've checked up the, after this matter was over, my lord, I've checked up the recording that is there.
Okay, anyways, plus just tell me, what is the date for drawing up the lots?
It
24th.
started yesterday. It is up to 24th. 24th.
Then 500 will be
370.
372 will be first selected. Then they will have to purchase the vehicle.
Yes.
And then there will be there will be NOA.
Yes.
NOA. Draw of lot is 24th.
And my lord, there is one more thing. If your lordship kindly comes to that order.
Let us do one thing.
Yes, my lord.
Let us do one thing. let us this since let us hear this matter all together on Tuesday.
Okay.
On
They are not.
Wednesday, because you are drawing the lot, it will sometime take some time to award and to purchase the vehicle. Till then, no third party right will be created until and unless you award. So even if we allow this petition, third party right will not be violated until and unless award is given.
Yes.
So on Wednesday, we'll hear this matter. Then I do not think you will issue any award within Thursday.
That position has been clarified by the division bench. If your lordship will take up the right for a moment, your lordship will take up the right. When the learned single judge has expressly taken note of all contentions and rejected the interim order. Against that, they preferred this writ appeal, and this is what is recorded. If your lordship will kindly come to paragraph 9 at page 26. Yeah. Mr. Rai Chaudhary, Learned Senior Counsel, has further submitted that the modified policy coming into effect in pursuance to this said tripartite meeting was put to challenge before this court in the proceedings of so and so, and this court was pleased by order dated so and so to reject the said challenge. Mr. So and so.
Now I understand what is his argument is that policy is fine.
No, that policy includes
Policy
the policy includes draw of law.
That I understand.
Policy includes draw of laws. That is what is that has been suppressed in the writ petition, and we have brought it on record in the affidavit. That policy includes draw of laws.
If that is there, then it will be difficult.
Your lordship will kindly see our affidavit.
Oh, my lord,
Policy includes draw of laws.
clarify one thing.
See
Now
what
we are
I understood that I'll express first. Then you
Yes, yes.
what I could gather from your argument to frame it
Yes,
that policy is fine.
yes.
Policy is fine, no problem with us. But when this policy is implemented, there should be an element of fairness, which
Transparency has to be there.
transparency and fairness. Therefore, it should be there.
Yes.
Now he says that so far relating to this prescription of draw of lot is also a part of the policy.
That agreement, I'm told, that between the district administration, ONGC and the petitioner, that is yet to be, my lord, very codified, na?
We have filed an affidavit.
Tuesday.
Wednesday.
No, my lord, there is one more thing. There, the policy says we'll adopt Oil India model. And Oil India tender was annexed before the writ appellate court. It does contain all the provisions.
So therefore,
Yes.
where will
Yes.
Considered
We'll
and
bring it on
rejected.
record. We'll bring it on record. Here,
Considered and rejected.
Wednesday. Whatever you want to file it on things. We'll give. Since this matter is urgent, we'll
Tuesday, my lord.
Wednesday. He's
Monday,
returning on.
But my lord, I can appreciate Monday, Tuesday, otherwise, my lord, my petition becomes infractuous.
No, it will not become infractuous. Suppose they do a draw of lot, let them not disclose it.
Yes,
Till
that,
Wednesday.
at least that part may be said.
So what let me be fair, man. First, let me just in brief indicate what has happened, what used to happen earlier
No,
here.
we'll hear you. Just my expression. I'm saying.
I appreciate.
See, time is not permitting. We are fixing this matter on Wednesday. You ask your client that don't.
No workout has.
No,
but
they will not announce the result of drop.
No announcement is in the website.
No, they will not.
We are doing it live on
Cross lock
YouTube. On YouTube,
Online
we are
connectivity.
showing to show the transparency. We are showing it on YouTube. It is available online. Everything is disclosed.
like drawing this lottery and all.
Yes. To maintain the same fairness that is being talked about. There is a logic. Earlier.
No, understand, because this is a very hard bond. Somebody will get a vehicle, somebody will not. This is a lottery. So therefore, at least you want to assure that we are clear. This is the lot that we understand. But cannot it be postponed to 25th?
Yes.
There is a problem.
Just ask your client.
Yes.
Because of the time constraint. That is your difficulty on Monday.
Not that they are bound to follow.
No,
My
lord. No, that is there. There is no
Because-
problem on that. What I'm saying is, Mr. Chaudhary, since you are having a difficulty, you are a big organization, you are waiting it.
Yes.
Wait till Wednesday. We are deciding this matter on Wednesday. That's all.
Without instruction, it is difficult to, my lord.
So have this instruction on Monday.
Yes, Monday.
In that case, my learned friend.
See, otherwise I could understand what is your point and what is his point.
Yes.
Even we can consider the interim on Monday once again.
Yes.
If you
Let
with
it
your
be-
instruction.
I will not be available, so my friend will give the instruction.
Just have it.
Otherwise, my lord,
No, I
with
understand.
greatest respect,
understand.
there's
Only
absolutely-
because of the time constraint.
IA
Otherwise not.
And
And
I can place judgments.
You
The
can-
only thing that is required to be decided is how much cost.
whatsoever,
There are judgments.
Mr.
It's an
Chaudhary,
abuse of the process.
whatsoever is there, the judge will have to write a judgment, either giving him a stay or refusing him a stay. That's all. Even if we put
That's
cost,
what-
that will have to give a reason. That difficulty is there because otherwise it's in the nick of the time, 24th and 20th, and you are having a problem on Monday and Tuesday. Otherwise, we could have fixed it on Monday.
In that case, my lord, your lordship will have it on Monday. My friend will produce the instruction. I will submit a short written.
You have a virtual argument hearing.
But
from-
Arunachal, I can, but
Try,
Arunachal,
but we are having it election petition through virtual.
in that case, I'll try.
You try it, make a request, we'll have it on Monday.
Very well.
Okay.
My lord,
See, in such a situation, we'll have to do something.
my lord, my lord,
Either rejecting or accepting,
Oh, yes, yes.
my-
either way.
my lord.
Deeply obliged.
List this matter on Monday. In the will not say anything. You have the instruction. Since Monday we are taking.
One.
Is this Monday one again on Monday?
Deeply.
Yes. That's all.